Maybe. Bail application, file long back, only custody. Just our tomorrow,
Next week on a date to be fixed by registry.
then Monday.
Next. Yes,
Monday,
next.
Wait, please, Your Lord. But I have a small correction, my lord. I am filing IA, my lord, in the order, my lord.
Passed by me. When?
My lord, it was
When
passed
do you require?
tomorrow, man.
Okay.
I'm obliged.
May I please, Your Lordship? I beg to mention that I have filed a petition of urgent nature. Yeah, Your Lordship may permit the
What
petition to
petition?
be listed tomorrow, my lord.
What
on 19th,
petition?
My lord,
What petition?
criminal petition, it is in connection with an appeal which has been fixed in the 23rd September next. The appeal has
Next
been-
week on a date to
so
be fixed by
I beg
registry.
to mention that it is of urgent nature.
Next week on a date to be fixed by registry.
My
So
lord,
tomorrow we are full.
On the Monday,
Next item.
Lordship, I need to pray before update the item number 51, Lordship.
No upgradation.
Lordship, actually, already 3 times it has been listed, but
No
not,
upgradation.
and the final, by tomorrow, Lordship.
I am speaking in English. No upgradation.
May I please, Your Lordship? My lord, a motion matter, my lord, on 12th of August, matter was listed. But some due, when that problem, I could not, my lord,
Next week on a
yes.
date to be fixed by registry.
yes.
My lord, criminal petition pertaining to quashing of NBWA, my lord. Some urgency there.
Next
Apprehension
week.
of arrest, my lord.
Next week.
Monday, next week, Monday, my lord. may I
No,
pray?
registry to fix the date.
I beg to mention with Jimma petition, my lord. On Monday, my lord.
Next week,
Date may be.
registry to fix the date.
My lord, it's a delay condition in appeal, my lord. The accused is in the jail for 1.5 years, my lord. Next week, my lord.
Okay.
Earlier.
Maybe. By beg to mention, I cannot 59, my lord. Unless 7 of them was listed but did not reach, my lord. Can I pray for upgrade?
No.
Now, please, Your Lordship. Lordship, I beg to mention listing of an anticipated bail petition, my lord, filed on 16th, my lord. And it is a family matter, my lord, and one person have already been arrested. We are apprehending, my lord. Monday, my lord.
Monday ki mana se?
Monday is 22nd.
Ki mana se? No, it will be automatically listed by the registry. If it does not get listed on Monday or Tuesday, then you may mention.
I already got interim bail from this court, Lordship. I got information that another case is lodged against me in the police station. And I am unable to appear before the IO, Lordship. As such, I am filing another case, Lordship. Kindly fix the matter tomorrow.
When have you filed?
Yesterday.
Next week, Monday or Tuesday?
Monday, if possible, Lordship.
No, registry to fix the date.
I am apprehending.
All are apprehending. Registry to fix the date.
Please, Your Lordship. Lordship, I beg to mention item number 41, Lordship. Kindly adjourn for the day, Lordship. N.A. Begum.
Miss N.A. Begum, learned counsel for the petitioner, who prays for an adjournment. Why are you seeking adjournment?
My senior is not
On the ground of
available.
personal difficulty of the conducting counsel for the, you're on interim.
Yes, Your Lordship. We have already taken.
Case diary is there.
Lordship.
You have any objection?
No, Your Lordship, no objection.
The prayer is allowed. Let this matter be
After we can.
29th of October. The
Sorry.
interim order shall continue till next day.
Okay, sir.
Maybe, Lordship, I beg to mention the BA, Lordship. Lordship, it was last posted on 8/9/2025, and the order was placed after 1 week. Lordship, thereafter almost 2 weeks gone. It was not lodged. I approached the registry on Monday and Tuesday also, but it was not.
Next week on a date to be fixed by registry. You give the mention number.
Already I approached.
No, this time mention memo will go.
If you oblige.
May I plead your lordship, listing for withdrawal of a criminal revision, your lordship.
Tomorrow.
Lordship. Oblige your lordship.
May I please, Your Lordship? I will to mention for listing of a IA for withdrawal.
Tomorrow
Monday.
on Monday.
Your Lordship.
I beg to listing for this AB Lordship. It was last listed on 25/6/2025. I have approached the registry also, but till today it is not listed, Lordship.
Next week on a date to be fixed by registry.
And can we fix a date, Lordship?
No, registry will fix the date. You mention in the memo
Yes,
that
yes. Last posting
Yes.
date.
registry will give a date.
Obliged, Lordship.
Your Lordship, for listing of a criminal petition for withdrawal on 23 of this month.
Okay.
Obliged.
May I please, my lord, I would like to mention one criminal petition that has been filed last week. My lord, in this case, warrant is still issued. So my lord, I can fix it on Monday.
Not on Monday.
My lord,
Next week on a date to be fixed by registry.
my lord, I kindly fix it on Monday.
No, we are unable to finish our list if we,
That I understand that.
so let the registry to,
Positively on next.
okay.
May I please, your Lordship, I may be allowed to withdraw for tomorrow.
Okay,
BA.
okay.
May I please, your Lordship, I beg to mention item number 26 may be adjourned for the day.
What is your name?
And no, on behalf of ESCOM.
Miss New Learned Counsel for the petitioner who prays for an adjournment. The prayer is allowed.
26, na?
Let this matter be
Yes.
listed in the next week on a date to be fixed by registry.
May it please, my lord, prayer for withdrawal of a criminal petition matter, my lord.
When do you want?
Tomorrow,
Okay.
deeply obliged.
Lordship, I beg to mention an IA for listing. It was listed last on 8th of August 2025.
I have for suspension
IA for suspension of
next week on a date to be fixed by registry.
obligement.
Yes, please. So I beg to mention for listing, my lord, on criminal petition, my lord.
Next week on a date to be fixed by
Yes,
registry.
Item 55 for withdrawal.
May I please, your Lordship,
What is your name?
A.E. Khan.
What is your name?
A.E. Khan.
You are submitting on whose behalf? Your name is not there in the,
On behalf of IS Law Firm.
heard Miss A.E. Khan, Learned Counsel, submitting on behalf of Mr. I.H. Laskar, Learned Counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application. Instant criminal petition, prayer is allowed. This criminal petition is dismissed on withdrawal.
Item 56.
What is your name?
Lordship P. Kakuti.
Heard Miss P. Kakoti, Learned Counsel for the petitioner, who prays for allowing the petitioner to withdraw this bail application. The prayer is allowed. This bail application is dismissed on withdrawal.
Both of the item 1.
Milord. This item is from the same CD as in item 38. I think item 38 CD has been received by my friend, so if it can be taken up also. Both of them were arrested in the same crime
We'll
branch too.
Take it up with 38 or,
Yes, sir, no, Malad, at the time of bail hearing, Malad.
okay, we'll take it up along with,
Because there's certain observations in the CD I'd like to
Yes.
point out to my lordship.
we'll take this one along with item number 38.
Milord.
But regarding Malad, here Malad, regarding juvenility Malad, it was directed to the Malad Planet Session.
Report has come.
Malad, that report has not come. Malad, I have talked with the Malad IO. He said that once it was produced, but it was not done actually. Maybe tomorrow. Malad, I
What
don't know.
happened actually, my lord, on Friday, the accused was produced. The accused was so terrified that the district and session judge, he could not answer the district session judge. He asked, district session judge asked us to produce a family member who was who appeared in court on
Okay,
Monday.
we'll take it up along with 38.
My lord. So medical board has been constituted for a bone ossification.
Okay. We'll pass orders when we take it up.
Milord.
Lordship, 43 bail application. Well, FIR is on page 13. Well, if I is registered under POXO Act, my lord, when notice need to be served.
Mr. What is the name?
B Sakya, my lord.
B. Sakya, learned counsel for the petitioner. Also Mr. K.K. Parashar. It is pending investigation.
No, it's submitted.
Let the scan copy of the trial court record along with scan copy of the connected case diary be called for. Let also notice be issued to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 in pursuant to the prevailing notification of the registry in this regard within 3 days from the date of this order, returnable on 17th of October.
Well, can it be on before vacation, my lord?
No.
No. Notice will not go on.
17th October.
What's it?
May it please your lordship. Lordship, this is a application filed under section 483 of the BNSS. Lordship, you will find the FIR on page 12. Lordship, may I read the FIR?
How long you are behind it? It is pending investigation.
Yes,
Lord- Lordship, all the
on
material.
5 lines. Page 5-9.
Lordship, I have been in judicial custody for 12 days and all the materials have been seized from me.
Why the prayer was rejected by the trial court?
Lordship, we have approached this honorable court directly under 483.
Case diary. Mr. What is your name?
Hey, Tarafdar, Lordship.
A. Tarafdar, learned counsel for the petitioner. Also Mr. K.K. Parashar. Let the case diary be called for.
Your pleasure.
Let this case be listed on
Lordship,
before vacation,
26.
26th.
Humbly obliged.
Item 4. May it please. The regular bail application, today is 55 days, my lord, petitioner is behind the bar. Although case is registered under section 6 of POXO, but the case is basically a child marriage case, my lord. Also, may kindly have a look at the FIR, vernacular at page 20, my lord.
Who is the respondent number 2?
Respondent number 2 is the Panchayat secretary, he has lodged the FIR. At page 20, the vernacular FIR, my lord. Minito Hanman Hogare Jonaze, Joa Ingraji,
Who is the victim?
my lord. Victim is wife, my lord. Lordship, may kindly have a look at the medical card, health card. She is pregnant of 6 months. While she attended the hospital, it has come to the
But father, no name not been, is not been disclosed in the petition, my lord.
father's name is not there in the record of the lord.
Issue notice to the father of the victim girl, victim woman. The petitioner shall furnish the address of the father of the victim girl and implead him as respondent number 3 in this case by filing an amended cause title. The petitioner shall take steps for issuance of notice on the
After
said on the father of the victim girl within 7 days from the date of this order, returnable on 23rd October. In the meanwhile, considering the fact that the victim is pregnant, victim is carrying pregnancy of how many months?
6 months, my lord.
Of 6.
and under section 483 of BNS. Lordship, notice may be issued at this stage. CBN notice, ma'am.
POXO,
POXO,
heard Mr.
you doctor.
U. Dutta, learned counsel for the petitioner. Also heard Mr. K.K. Sharma. Call for the case diary and issue notice to respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice within 3 days from the date of this order, returnable on
15th October.
15th of October.
Scan copy of trial for movie call.
NDPS.
DPS commercial.
Heard Mr. K. Thakur, learned counsel for the petitioner, also heard Mr. K. Parashar. Call for the scanned copy of the trial court records along with scanned copy of the connected case diary. Release this matter on 29th October. No.
7. Scan.
Scan copy we have got.
Same order. Heard Mr. N.J. Datta and Miss P. Upadhyay, learned counsel for NCB. Call for the scanned copy of the trial court records along with the scanned copy of the connected case diary. Release this matter 24th October.
Procedure case, madam, have submitted some documents, madam.
Those-
WhatsApp messages are photographs.
Those
The case of-
documents,
WhatsApp messages, madam, photographs.
those documents are not in the, you have not annexed those documents,
For the sanctity of the girl, madam, I have not annexed.
then why are you showing it to me?
No, I have, madam, in the petition, madam, I have categorically stated that I have carefully, madam, to produce the document at the time of petition. I have especially stated, madam, page 5.
We have
madam.
given a copy of this to the,
Well, no, at this stage, madam, this is a case of, madam, side measure, exactly as the side measure. Can you finally, madam, FI, madam, page 14, madam. Even FI stated is a case of side measure. Page 14, madam. And initially, madam, POXO was not added, madam. Subsequently, POXO was added. May I read it? Page 14.
no, if there is a case of child marriage where sexual intercourse has happened, then will it not come under POXO Act also? Yes or no?
But can you, page 14, can you have a look, madam? সম্মান সহকাৰে জনাও যে যোৱা ইংৰাজী 10/8/2025 তাৰিখে দিনৰ প্ৰায়
from mile 26/8/2025 miles. FIR page 14 mile type code. The mile in this case only the co-accused who was arrested, he was granted bail by the trial court itself. While my petition was
Why your prayer was rejected?
well only because the initial stage of the trial. So lots of kindly.
And when the co-accused was granted bail?
He was the copy I have annexed page 21 on 3/9 miles. My bail petition was rejected on 8/9. But there is no, the sections charged in the FIR mile are not affected except section 318 mile. And the petitioner is a woman male, her son male, 6 years old male, is suffering from heart problem male. The mother male whose son male is suffering from heart problem, where she will male plea male, if the bail is granted to her. I have annexed all those documents, male, medical documents.
What is the FIR? Let us read.
FIR page 14 male, type copy. There is allegation of misuse of some government sponsored scheme, my lord. And there is no date when the.
We fix a short date. Yes, Mr.
Co-accused has been released on bail, madam. My son is suffering from heart problem.
But co-accused has been released and same court
Same court.
rejected
On
your
the
bail.
ground of medical ground, my lord. My problem is that my son is suffering from heart
But
problem.
same court rejected your bail after perusal of the case diary. So there must
Same
be.
allegation, my lord. Only CDR is available against with the main accused, my lord. Main accused are like state at large.
Heard Mr. P.J. Soikan, London, counsel for the petitioner. Also heard Mr. K.K. Parashar. Considering the nature of acquisition made in the FIR, perusal of the case diary is felt necessary for consideration of the instant bail application. Hence call for the case diary. Release this matter on 25/9.
25, my lord. How like?
Item 10.
25.
My lord, the petitioner in pursuant to the FIR, which your lordship will find the page 15, my lord, page 16, He was arrested on 1st of September. The FIR was registered. FIR is dated, my lord, 25/2025. Kindly take note of the date, my lord. Page 16.
Wildlife Act,
Yes, my lord.
what is the accusation?
Regarding recovery of some elephant tusks, my lord. In respect of same allegation, petitioner was already granted bail. Lordship will kindly come to page 23. Was granted anticipatory bail by this honorable court at page 23.
Same or similar?
Similar, my lord. Because what happened, my lord, I had made specific statements in the petition. The petitioner is an active member of the PPF party, and he was politically active, and to keep him out of the election rally, all these FIRs has been raised. My lord. In fact, my lord, one anticipatory bail application is coming as item number 18 before this honorable court today. He has not been arrested in that case, my lord. After that, my lord, that FIR that in which I have got bail was registered on 16/5/2025. And this FIR is dated 25/2025. Lordship, kindly turn to page 16 for a moment. FIR dated 25/2025.
Yes.
Date of FIR, Amguri PS, GD entry number so and so, dated 25/2025. Here, name of the petitioner appears at page number 17, serial number 8.
Yes.
Her name is written as Ansula Basumatari. It's Ansula Narjari, actually. After that, we have that in that anticipatory bail, the offense was committed, Lordship, if your Lordship peruses the order at page 24, the FIR dated 16, page 24, I'm reading, my lord. The FIR dated 16/5/2025 reveals that 1.5 years back, an elephant was forced at so and so, so and so. Well, but if your Lordship peruses the present FIR, no date has been mentioned when the offense was committed, my lord, at page 16.
16 is the present FIR.
Yes, my lord. No date is mentioned when the offense was committed, by whom it was committed, my lord. May I read it, my lord?
No, but
I'm checked it also.
no,
there, my
it
lord.
may be in respect of
No.
another elephant.
No, my lord. It may be, my lord. Assuming for a moment. Well, why, my lord, immediately, if I was, after my statement was recorded, I was arrested, my lord. They could have searched me prior, or if that is so, if it is not at all politically motivated, from May till September, I was not arrested. I was arrested only after granting of bail by this honorable court in respect of the previous FIR. That FIR was registered on 16/5. This was registered on 28th of May.
Where is the previous FIR?
That FIR I have not annexed, my lord, but this is the statement from the court's order, my lord. At page 24, Lordship may kindly read. FIR
Then
dated 16/5.
Case diary would be required.
Yes, my lord. A short date, my lord.
Heard Mr. T. Chakraborty, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. Call for the case diary. Let this matter be listed with 26th of September.
Apply.
11.
May I please, your lordship? 35 days in custody, lordship, under section 72 BNS and under section 6 POCSO Act, lordship.
Okay.
FIR is on page 10.
What is your name?
KLR
Heard Ms. K.L.R. Yanthan, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. Call for the case diary
17th of October. my lord.
and issue notice to respondent number 2.
vacation,
Before
Puja
vacation.
vacation,
Before vacation, it
Further
may be
police
difficult.
not come, my lord.
before vacation, lordship.
It may be difficult.
Notice has to be served.
Issue notice to respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice within 3 days from the date of this order, returnable on
Before vacation, Lordship, 3 months, it's about to complete 3 months, Lordship. The petitioner is about to complete 3 months. 35 days is in jail custody.
now
85 days,
35 days,
85 days, Lordship.
85 days
Yes, Lordship.
on 26. 26 May.
Item 12.
Let me, your lordship. This is a bail petition for a pregnant woman. She is carrying 8.5 months and behind the bar for the last 43 days. The allegation is a recovery of 93.55 grams of heroin from her house. FIR is
93.
at page 13, lordship, 12 and 13. The medical report, lordship, confirming her pregnancy and expected date of delivery on 1/11. She is behind the bar for last 43 days.
Why the trial court rejected?
On this simple ground that considering the facts and circumstances, lordship, I have that order also, lordship.
Yes.
FIR is at page 12, lordship. The first paragraph shows that her husband has been tagged as a peddler. May I read, lordship? This is to inform the reliable information was received from a source by OC Lahori Ghat at 1:25 AM. At page 12, lordship.
Yes.
Today on 7/8/25, as per the information, one was selling suspected to be heroin near Borbori under Lahori Ghat PS. The informer also revealed that the peddler is involved in illicit trafficking of the drugs and he likely to take away the consignment from that place to some unknown destination. At midnight, 1:30 PM, house was raided. The lady was alone in her house. Then
Yes.
some vials were recovered,
79 bells are recovered, well, seized.
93 grams.
Total 93 grams.
93.55 grams. And she was arrested on that night, brought to the police station in violation of all the provisions of PNSS.
Heard Mr. S.K. Poddar.
And
Then,
she's carrying
yes,
lordship.
Mr. Parashar, do you have anything?
Interim only regarding the medical purpose, but CB
Otherwise, 60 days. lordship.
60 days will be
43 days
over.
she is behind the
during
bar.
Heard Mr. S.K. Poddar, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner Musammat Fatima Khatun, who has been detained behind the bars since 7/8/2025 within bracket for last 43 days in connection with Lahori Ghat PS case number 171/2025 under section 21B of the NDPS Act. The gist of accusation in this case is that on 7/8/2025, one Juganta Medhi, SI of Police of Lahori Ghat PS had lodged an FIR before the officer in charge of Lahori Ghat Police Station, inter alia, alleging that an information was received through reliable sources regarding selling of heroin near Borbori under Lahori Ghat PS. On receipt of an information, a police team was constituted and the residence of Afzarul Hussain was raided. During the search operation, your husband was not found.
He was not there on that day.
Husband of the petitioner was not found. And how much contraband?
93.55 grams.
And 93.55 grams of suspected heroin was recovered therefrom. Learned counsel for the petitioner has submitted that on perusal of bare perusal of the FIR would show that the information received by the police was regarding involvement of the husband in the suspected, in the recovery of the suspected drugs. When the police raided the house of the petitioner, as she was found therein, she was arrested. Learned counsel for the petitioner submits that the petitioner has been detained behind the bars for last 43 days and she is carrying a pregnancy of 8 months. In support of his submission, learned counsel for the petitioner has produced a medical report, a copy of medical report issued by the Medical and Health Officer, District Judge Morigao, which shows that the petitioner is carrying a pregnancy of 8 months. So, I have also heard learned in additional public prosecutor. Considering the submissions made by learned counsel for the parties as well as materials on record, it appears that the quantity of heroin recovered from the residence of the petitioner is an intermediate quantity and therefore embargo of section 37 of the NDPS Act is not applicable to this case. Moreover, considering the advanced stage of pregnancy of the present petitioner, this court is inclined to grant bail to her. Accordingly, the petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of learned Special Judge Morigao with following conditions. Trial condition, investigation condition. This bail application is accordingly disposed of.
This is a POCSO case, Lordship. A kid is a 62-year-old and a psychiatric patient, Lordship. He is behind the bar. We have come up this petition.
Notice will go.
Notice will go because notice will go to the government also because the informant was lodged by the police. One WSI of Patan Bazar PS.
No, notice will have to go to the
Victim,
guardian.
We don't have the address. There is no address of the victim nor her parents. We don't have that part, Lordship.
That the police will.
Okay, we'll issue notice.
I will
to the-
Lordship, may I submit something more, Lordship? In this case, mainly you have come up with on medical ground, Lordship. The patient has to remain in GMCH for about 20 days, more than 20 days, Lordship. He is a psychiatric patient. We have annexed several documents here, Lordship.
Who is the victim?
Victim is one, the gist of the case is that the accused taken away one 15, 16-year-old girl to the cinema hall, forced her to undress and committed some anal penetration. That is almost
Okay.
quite impossible. But the second part is our come on the law point, Lordship, total violation of 47 and 48, Lordship.
We'll peruse the case then.
Lordship, may I just draw on attention page number 25, Lordship. Just 1 minute for Lordship. 25 page number. What the so-called 47 has been issued, not a single. Bihan Kumar has already been explained.
Page number?
25, Lordship. So I have annexed the 47 certified copy. We have obtained from the copy records. The grounds of arrest. The arrestee accused person is FIR named accused. The crime committed by the accused person is heinous in nature and prevent him from committing the repeated offense. The arrest accused confessed his guilt before the IO regarding commission of the crime. Sufficient evidence have been found against FIR named accused. If the accused person is not arrested, his presence before the honorable court to police cannot be ascertained. The accused person is arrested, providing honorable court only to prevent him from, these may be the reasons of arrest. This cannot be the grounds of arrest. Not a gist. Honorable Supreme Court in the case of Bihan Kumar and subsequently on this Krisa Reddy, Upendra Reddy case also, Lordship.
that 47 has to be complied with meaningfully. The gist of the accusation, why you were arrested, what offense I have committed. Not a single line here, Lordship.
3-year-old person was rendered in the cinema hall, and in the forwarding report it is given that Malak earlier also he took the girl, Malak.
That is the one part, Lordship. But I have to be informed, that is my constitutional right under 22, Lordship. Second part is, Lordship, under 48.
Given.
If Lordship goes to the page number 27, Lordship. At page 28, Lordship, it was handed over to one Jamir Hussain. Not a single accused is a resident of Guwahati, having a permanent residence at Goripur.
Maybe the authorized person is a.
No, he cannot be an authorized person. He is a man of Patasi Lambadi somewhere. We have, on the given contact number, when we have tried to contract, he is a rickshaw puller of the Patan Bazaar PS, near, resides in the Patan Bazaar PS. He is no way connected.
Yes.
Can be
Relating to 47 notice.
Reviewed from the city, Malak, and regarding.
We will not change this part, Lordship. It has been a certified copy. We have not given our copy. That's why. This may create a doubt. That's why we obtained the certified copies, Lordship, and we have given it, Lordship. This is the certified copy obtained from the records. Schedule reveal this. Definitely, it will not change, Lordship.
Where is the certified copy?
These are this.
This is the photocopy only.
No, certified copy I have, Lordship, with me.
You bring that certified copy on record. We are fixing a short date for case time. Short date for case time.
This is a clear violation of 47, Lordship. In the latest Supreme Court judgment, in this Krisa Reddy, Upendra Reddy, 47 and 48 has been clearly,
No,
it
but
has to be
certified,
meaningful one.
yes. It appears that 47 may be lacking, but certified copy has to be brought
I
on
have
record.
with me, Lordship.
No, it is with you only.
Lordship,
Not in this manner.
copies, Lordship.
Not not in this manner. You.
I can file an additional affidavit.
Yes, you
Day
can.
after tomorrow, Lordship.
Not
Monday.
day after tomorrow.
On the Monday, Lordship.
When can you bring the case in?
24.
24.
Okay, Lord.
Heard Mr. S.K. Poddar, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner. Under petitioner, namely Anup Kumar Patwari, who has been detained behind the bars in connection with Paltan Bazar PS case number 229/2025 under section 65 within bracket 1/87 of BNS, read with section 6 of the POCSO Act. Learned counsel for the petitioner has submitted that the FIR in this case was lodged by 123. The learned counsel for the petitioner also praised for allowing the petitioner to file an additional affidavit to bring on record the certified copies of notice under section 48 and 47 of BNS as issued in this case. His main contention in this case is that the notice under section 47 and 48 do not mention about the grounds of arrest. Neither it mentioned the basic facts which necessitated the arrest of the petitioner in this case. Let the case diary be called for. Let this case be listed on 23rd of September.
Obliged, Lord.
Now, if earlier the case was different, suppose now if police do not comply with the 47-48 notice properly, then they are liable to be subjected to departmental proceedings. Because earlier the situation was they may plead ignorance, but now it is very clear. If in spite of knowing the law, they don't comply, then they have to face consequences. Okay, 23rd.
Item 14.
My lord, diary may be called for my lord, in the instant case, my lord.
What is the offense?
My lord, it's a NDPS, my lord, although it has been registered as C, my lord. My lord,
Okay.
document-
Heard Mr. N.J. Datta, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. Call for the case diary. When?
My lord, on 24/09/25, along with my lord, BA number 2895.
Okay, learned counsel for the petitioner submits that in a connected case, case diary has already been called for and the next date is fixed on 24/9/2025. Let the case diary be called for. Let this case be listed along with BA number 2895 on 24th 2895/2025 on 24/9/2025.
I'm of that.
15.
May please, your lordship. My lord, here, FIR is at page 10, my lord. Allegation is that of an attempt, my lord, under POCSO Act. So, my lord, my humble submission at this point of time, my lord. Notice may go, my lord, and case there may be called for.
Heard, Miss.
Only prayer, my lord, I pray that it may be listed on 26, my lord, because it's in case of an attempt, my lord.
But whether notice will, it depends
I
on.
will take step today, my lord. Let us take a step.
Heard Mr. T.H. Hajorika, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Let the case diary be called for. Let also notice be issued to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by registered in pursuant to the prevailing notification of the registry in this regard. Within 3 days from the date of this order, returnable on 26/9/2025. List accordingly.
I'm deeply obliged. Deeply obliged.
May I please, your lordship. So this is NDPS commercial case, my lord, third fitted case under trial. TCR required, my lord, in this.
Heard Mr. A.K.
My lord,
Azhar.
I have online submission before calling the TCR, my lord. Kindly use the page 42.
What
my
is
lord.
your submission?
My lord, notice under section 48, my lord, that is issued, that is available in the record, but that is not served upon the accused relatives or any.
Heard Mr. A.K. Azad, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Call for the scanned copy of the trial court records along with the scanned copy of the connected case diary. Let this matter be listed 24th of October.
24th of October. Just one line, my lord, in this, I have annexed the 48 notice, my lord.
On next date.
My lord.
Next date. Let the record come.
57 of supplementary.
50.
My lord, your lordship yesterday that matter, my lord. Customer has not made party. It's already made party, but it has not come in the, they have already supplied copy, my lord, to them.
No, it has not come.
But yes, that is issue today.
No, that has to come. Okay.
So in that come after some time, my lord, because it is already
Okay,
there.
call for the amended cost.
Yes.
Item 58.
Amended cost title call code.
Yes. My lord, FIR is 9A. But here, my lord, earlier there is an application, AB, and that was withdrawn because during the pendency of the bail application, the present Gopal Sutradhar was arrested. Now, Lordship may kindly see there is no grievance against the present accused person by the informant. Kindly see the page 20, page 20.
What is page 20?
Page 20, right. This is sworn in by the informant of the case. Kindly see page 22, bottom.
Who is the victim?
The victim is my lord Papia.
And who is the informant?
Informant Raju Sutradhar, her father. So her father saying that if the present accused person is granted bail, he has no bail or acquitted, he has no objection, madam. That is shown in before the registry.
He may not have objection. Victim may have objection.
My lord,
The victim girl may have objection,
victim is a minor, madam.
but she may have objection.
My lord, how she can swear an affidavit? She is minor.
In pursuant to the prevailing notification of the registry of registry within 3 days from the date of this order, returnable after puja vacation,
No, no, no. Because better is compromise.
on returnable on 26th.
So many already matters speaks, madam. Otherwise, notice
20
notice has
or
to be
23, my lord.
No, how notice will be served?
The notice automatically he will come because they have compromised the matter. So
Case
far,
diary?
So my lord, informant duty is to malad file the FIR malad.
Yes.
Such a case, POXO cannot be compromised, malad. Though they can say malad,
that
it cannot be. Only they can only file the FIR, malad.
No, we'll peruse the statement of the victim.
I agree
Statement of
with
the
my
girl
learned
is-
friend that it cannot be compromised.
So girl
26.
rape
26.
person and
No,
now
that,
father is.
that is not yet proved. It is allegation.
Why, whether it is misunderstanding, my lord. FIR says the rape. Whether it can be, my lord.
Yes.
My lord, this is the word of the parties, not my my lord. So misunderstanding. My submission is, my lord, let it be on 22nd, my lord.
No, 26.
26, my lord.
22nd, you can bring the case.
Weeks, my lord, we can perish. How can the court?
Let it come. If it get left over, it will come after puja vacation. 26.
26.
Item 17.
26.
26.
May I please, Your Lordship? Your Lordship, section 6 of POXO Act was subsequently added, Lordship, against the prime accused, Lordship. He was arrested, he was released on bail. Lordship, may I kindly come to page number 27 for a moment.
He was arrested.
And released on bail.
No, and
The prime accused. Against whom, Lordship? Lordship, may I kindly come to page number 27 for a moment. The petitioner before your Lordship is the brother of the arrested accused person who was released on bail. Page number 27.
Yes.
Investigating officer, namely so and so, has submitted a petition stating that during investigation, materials under section 64, read with section 6 of POXO Act has come out against the accused so and so. Accordingly, he placed.
What is your name?
Lordship, the name of the present petitioner is Procedural. He is the elder brother of that person.
Rafiul.
Yes, sir.
Okay.
Earlier, Lordship, the case was registered under section 87. FIR, Lordship, is at page number 15. 15. Even, Lordship, in the FIR also, Lordship, there is nothing against the present petition. Only says that 3 persons were there. Page number 15. My
3
lord.
person committed rape.
No, no. Even allegation of rape is not there in the FIR. It has come subsequently. My lord, may kindly come to page number 15 for us. This is the FIR. May I read it?
Accusation is against whom?
Against Rafiul Karim, Lord. The third, last four line, Lord. The below mentioned accused person along with two other person came into a Swift Desire bearing so and so, kidnapped so and so. After 30 was informed from the mobile phone of my daughter to my mobile.
What has happened to the accused, main accused?
He was arrested and he got bail.
On what ground he got bail?
Default bail.
Default. Yes, Mr.
And another person who is named in the FIR, he is on interim bail.
He's on?
Interim bail.
Okay. We'll call for the case diary.
May I put for interim bail?
Yes. Heard Mr. M. Ahmed, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Razaul Karim, who is apprehending his arrest in connection with Kalaigaon PS case number 30/2025 under section 87/3 within bracket 5/64 of BNS read with section 6 of the POCSO Act 2012. The gist of accusation in this case is that on 1/6/2025, the father of the victim girl has lodged an FIR before the officer in charge of Kalaigaon Police Station, inter alia, alleging that one Rafiul Karim, along with two other boys, had kidnapped the minor daughter within bracket victim of the informant from her house in a Swift Desire vehicle bearing registration number AS01HC 3772. Stop. Learned counsel for the petitioner has submitted that why are you apprehending your arrest?
My name is there in that.
FIR.
Yes. Page number 16, serial number 2.
What is your submission?
My submission is that, my lord, I'm no way involved in the present case. My name is here as because lordship, there was a love affair between the LS victim and my younger brother.
Learned counsel for the petitioner has submitted that the main accused, namely Rafiul Karim, is the younger brother of the present petitioner, and therefore he has been roped in this case. He, however, submits that he is in no manner connected with the offense alleged in this case. He also submits that the main accused, Rafiul Karim, has already been released on bail, released on default bail. Okay, released on default bail by the Court of London, Additional Chief Judicial Magistrate Udalbari. Yes. We don't know actually.
Yes, Lord. That is true, lordship. Statement, so far as the statement part is, so far as
Yes.
so far as that part is concerned, my lord, may kindly once again peruse the order dated 19/7/2025.
Page number?
Page number 27.
Yes.
It has come out against the accused so and so, only one person. Section 6 and other things only against one person. And another thing is that in this case, lordship, the FIR was registered lost on 1/6/2025, whereas
Learned counsel for the petitioner further submits that while granting bail to the petitioner, the Court of Learned Additional, which court granted bail? Which is the court?
not annex the bail order. My lord, may kindly come to page number 22.
No, which court granted the bail? Bail to refuse. This 19/7/20.
Special just POXO Udalguri.
Where is that? From where are you saying?
Page number 9, page number 27, my lord.
No, the bail was granted by Additional Chief Judicial Magistrate. How? Oh, bail order is not there.
Bail order is not there. I have not.
So we don't know actually. There is no material apart from your submission. Wow.
My lord, I'm relying on that page number 27.
27.
27.
27 is the observation made by the,
While allowing the petition submitted by the IO
or,
for addition of section 6 of POXO.
okay. Okay. No. While allowing the petition filed by the investigating officer to add section 6 of the POXO Act to this case, it was observed that the material against section, there are materials under section 6/6 of the POXO Act against the petitioner Rafiul Karim. No, this is insufficient. Case diary would be required.
My lord, may kindly call for the case diary. What I'm praying for in the meantime, lordship may kindly protect me. That is what my prayer is.
No,
And
on
another
what basis I will
And
protect?
another person whose name is there at serial number 3, he is also on interim bail. His
Where-
bail is fixed on 26th.
Where is the interim bail order?
Lordship may kindly take up this matter after 10 minutes or at 12, Lordship. I'm furnishing the.
Tomorrow. You bring on record that material. You have to come prepared.
It's AB number 1429 of 2025.
Where is that?
Then Lordship, in that case, I have not annexed it, Lordship. I have not annexed it on the ground that while granting him the benefit of interim pre-arrest bail, at that point of time, only section 87 was there. Subsequently, my lord, in the month of July, section 6 was added. So his footing and my footing was different, considering the fact that at that point of time, while this honorable court was pleased to grant him interim bail, section 6 of POXO Act was not there. Now, that interim order was passed in the month of June, and section 6 was added in the month of July, 19/7/2025. So these are my humble submission, otherwise I'm leaving it up to you.
Okay. Para to cut off. Learned counsel for the petitioner submits that the order dated 19/7/2025 reveals that section 6 of the POXO Act was added to this case only because there were materials under said section against accused Rafiul Karim only. Rafiul Karim. No mention about the name of the present petitioner is there in the said order, while allowing the prayer for addition of this section 6 to this case. He therefore submits that there is no material against the petitioner under section 6 of POXO Act in this case. He further submits that in the meanwhile, one of the co-accused, Muhammad Saklin Mustaq, has been granted interim bail by order dated
My lord, fight order dated 24/6/2025.
24/6/2025, passed
AB
in
number 1429 of 25.
AB number 1429 of 2025. In that case, the case diary has been called for and the case is fixed on
26.
26th of
26.
to 26th of October. Hence, call for the case diary and list this matter along with AB case number
1429 of 25.
2024. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed herein above, the petitioner is directed to appear before the investigating officer of Kalaigaon PS case number 30/2025 within 7 days from the date of this order and cooperate in the investigation. If he does so, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on interim bail of rupees 30,000 of subject to the satisfaction of the arresting authority with following conditions, number 1 and number 2. List as earlier. List accordingly.
Highly appraised.
My lord, fixed on 26.
26, along with VAB.
Highly appraised.
57.
Your lordship, that has come, my lord. My case was by the 47, page of 48. It was applied to the accused himself.
We'll call for the case diary.
Yesterday, your lordship indicated that.
Heard Mr. H.R.A. Chaudhary, learned senior counsel assisted by Mr. I.U. Chaudhary, learned counsel for the petitioner. Also heard Ms. P. Upadhyay, learned counsel for NCB. No, learned counsel for Customs Department. Let the case diary be called for. Well,
After 2 weeks, Your Lordship, after vacation.
Which will go after vacation.
it is an commercial quantity.
It is there, but I am on page 30, my lord, 48.
Date
On the face of it, my lord, only, my lord,
15th October
after vacation.
after vacation. Otherwise, we will not be able to take up the cases. 15th October.
Their name may be recorded.
Yes, name of
Customs Department.
Customs Department, Standing Council Customs Department shall be reflected in the cause list. Henceforth, the registry to do the needful.
18.
Here, my lord, the petitioner is the same petitioner in respect of item number 10. The offense report topic will come to page number 12. Here, the name appears as accused serial number 2, Consular Narjari.
Page number?
It's a offense report number PB 1 of 2025.
Where is the page?
Page 12, my lord. 1-2. Lordship has got it, my lord.
Yes.
Offense report number PB /1 of 2025. Here name appears as serial number 2, Ansula Narjari. Allegation is similar, my lord, regarding recovery of ivory and arms. Lordship, the main accused was already arrested on arrest forwarding report that Sadin Narjari was arrested on 22/2/2025. That is the forwarding report. In respect of similar offense, at Annexer 3, page 17, the petitioner was granted bail by this honorable court.
No, but getting bail in a similar offense.
Yeah, but till date, although I was arrested, it was duty upon the authorities to inform about the other cases. The petitioner has not been arrested in this case, and he was not even informed because in connection with Anbari PS case, that Annexer 23, petitioner was arrested on 1st of September. That FIR at page 28. Till date, they have not interrogated. They could have interrogated me when I'm within the custody, my lord. If they are so interested to carry forward the investigation, my lord. I am still in custody in connection with a different case, but till date, he has not been interrogated by the investigating authority.
You are still in custody.
In connection with Ambari PS case, that page 28 FIR. Lordship has called for CD on 26th. In this case, I am praying for that if they want to take a statement, they can take when I am within the custody. Custodial detention may not be necessary at this stage, my lord, because I am already behind the bar in connection with other case. In this AB, I may be protected. Otherwise, my lord, I am also have a right, there is a violation of my right to know about the pending cases at the time of my arrest. Uday Chand judgment, lordship ever, my lord?
No, before you are granted bail,
Yes.
you have to be, the court has to be informed.
Yes.
But you are not yet you are still behind the bars.
I was granted bail in connection with AB, my lord. I am still behind the bar.
Yes.
I'll take instructions, my lord, in this matter, because he's already in custody.
They can interrogate you.
You have not, you don't require his custodial interrogation. If you have not prayed for showing him arrest in this case.
Because my lord, he's already arrested by police authorities.
But in a
But
different
for
case.
forest authority is it's a link case. Forest has registered a separate offense.
Okay, let him take instruction.
Either I may be protected, my lord, if something
No,
comes
question
up.
of protection does not arise because you are behind the bars.
In the event, my lord, what I am suggesting, in the event, lordship, after perusal of case there in the other case, if your lordship allows bail to the prisoner, then
When is that date?
Lordship,
In other case, when the date is fixed,
26th of September, my lord.
we'll fix this on
When-
26th. Heard Mr. T. Chakraborty. T. Chakraborty, London, counsel for the petitioner. Also heard Mr.
I brought Haku, my lord, on
I-
behalf of Special PP Wildlife.
I Bhattakur, appearing on behalf of Mr. D. Gogoi, Special PP Wildlife. This application under section 482 of BNSS has been filed by the petitioner Sadhin Narzari, Ansula Narzari, who is apprehending his arrest in connection with offense report number PB/01 of 2025 under section 39/49B/51 of the Wildlife Protection Act 1972. Learned counsel for the Wildlife Department has prayed for some time for seeking instruction. Learned counsel for the petitioner has submitted that in a similar case where petitioner has in which the petitioner is detained behind the bars, the case diary has been called for and the next date is fixed on 26th of September. Hence, let this case be listed on 26th of September to enable the petitioner, to enable learned counsel for wildlife to seek necessary instruction in this regard. Please accordingly.
Okay.
19. May it please again, my lord, page 40. Same case, your lordship already granted bail to the other co-accused. Page 40, as it is, same. Only in page 40, there are two petitioners. Here, there is one petitioner. Only the difference is petitioners and petitioner. Rest all same. Completely identical.
But that is 482 and this is 483.
No. Both are anticipated.
Oh, yes. Both are anticipated.
Same as it is. The only difference would be S, petitioners and petitioner.
and the name of the present accused.
What is your name?
My name is Bonita Goswami.
How you are related to Vishnu Goswami? And
Vishnu Goswami. These are all, my lord, they are all family members, my lord. And the main accused is this Ganesh Sharma. Ganesh Sharma is also on interim bail. Ganesh Sharma order, your lordship will also find at page 45. They are all family members. Page 41, identical, because the allegation is against Ganesh Sharma, and therefore your lordship did not consider absolute bail for Ganesh Sharma. In Ganesh Sharma's case, your lordship has called for the case diary, and rest, my lord, your lordship has considered, keeping in view that the allegation is squarely against Ganesh Sharma and the fact that there is a civil case pending against Ganesh Sharma and the informant side, which is an NGO.
yes,
Same, exactly. Okay.
heard Mr. M. Bishwas, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner, namely Bonita Goswami, who is apprehending her arrest in connection with Sipajhar PS case number 104/2025 under section 120B/406/420/468 of Indian Penal Code. The list of accusation, code para 3 from page 41. Code para 4 from page 41. 5. Six. 7. 8.
8, that S will be
8 in place of petitioners. It will be petitioner on mark kori this one. 9 also, instead of plural, singular number I will.
no, that would be 9 would be a bit different.
9 will be different. 9 is not required. 9 is not required. 10. Eleven. 12, 13, 14, 15. 16, 17. 17 changes, required changes. You appear before the IO within 7 days. And 30,000 with 1 surety of liking.
I'm deeply oppressed.
Disposed of.
20. May please, Your Lord. The criminal revision petition, whereby my account had been frozen by the police, my lord, during investigation. I filed an application for defreezing the account, my lord. That was rejected. Issue which your lordship will examine is if a person is not an accused in the case, because charge sheet has already been submitted. He is not an accused. Can he still be kept penalized, my lord? The lordship will.
You are not an
I am
accused.
not an accused in the case, my lord. I'll give all the documents, my lord. Everything is here, my lord. Page 20 is the FIR. my lord.
Who are the opposite parties in this case? Respond. Only state.
State.
Yes.
Page 20, my lord. May I read the FIR, my lord? with due respect and humble submission, I have the honor to report you that on 23/2025, I received a phone call from so number.
Why your account was?
Madam, next page, madam.
Okay,
Initial,
okay,
madam,
read.
give the gist, madam. My brother is one Raju, man. Now there's an allegation that this person Raju called the informant and offered to sell him a gold board, madam, which eventually turned out to be a fake gold board. In that regard, this informant had paid rupees 5 lakh rupees to the accused. Now,
Accused means Raju.
Raju, madam. Now, this FIR was registered on 10th of April of 2025. On 9th, my lord, on 10th, the IO submits a report before the police that my account, I am Rashidul Islam, that my account has been frozen. That is, my lord, important, my lord, page 21.
Page
21, my lord. Here it mentions that I respectfully report that in connection with the ongoing investigation, I have frozen the bank account of Rashidul Islam in coordination with SBI Bank Gusaigaon branch. He is allegedly involved in a fake gold smuggling operation and has been recently implicated in a case of fraud. Mr. Binod Kumar was reportedly deceived in a fraudulent gold dealing, resulting in financial loss of rupees 5 lakh. During investigation, links to a broader fake gold racket was placed to Rashidul Islam, who is suspected to be a prime accused. So at this moment of time, it is projected that I am a prime accused in this case. Now, my lord will kindly come to page 22. They've given the specific details of my account, where my account has been frozen. Now, page 23 is the charge sheet, my lord. And the relevant portion your lordship will find at page 35. Lordship would note, this is a different Rashidul. This is Rashidul Sheikh, son of late Noor Islam Sheikh. He has been shown as an accused. Moqsid Ali, Ayub, and Nurzul Islam alias Raju. So Nurzul Islam alias Raju is my brother. And another, my namesake, is also an accused in this case. These 4 persons. Additionally, my lord, next page, there are 2 more persons. Rafiqul Sheikh and Azizul Haq Sheikh.
What is your name? Rashidul
Rashidul
Sheikh.
Islam, my lord. Son of Rafiqul Islam. And your lordship will note number 5, Nozul Islam is also son of Rafiqul Islam. So this Nozul Islam alias Raju is my brother.
Okay.
So I am not shown as an accused in the charge sheet. Now I file an application initially, my lord, page 37 for defreezing my bank account. And page 39, IO gives the report. This report is important, my lord. This report again figures in the second half again, my lord.
Page 37
Page
is the
37 is my application, my lord. My order of my application, where I have made a Zimma prayer for defreezing of my bank account, my lord.
the report was called for.
My lord, on page 39, reasons for freezing the said account. Number 1 is important, my lord.
Yes.
The named accused in the FIR, Raju, does not have a bank account of his own. Hence, the fraudulent amount was directly deposited in the account of Rashidul Islam. So this is the reason why the police has frozen my bank account. Now, this bail application subsequently gets rejected at page 40. Then again, I file another bail application because by this time the charge sheet gets filed, where I am not shown as an accused. So again, I approach the trial court saying that earlier investigation was ongoing and you did not grant me the account. Now investigation is over, charge sheet has been submitted and I don't figure in the list of the accused person. So at this moment, this account may be defreezed. Now court again calls for a report from the IO following the charge sheet, my lord. IO again gave the same report that this, since Raju did not have an account of his own, this money was deposited in the account of Rashidul Islam and so his account was frozen. Now, my lord, 2 points. First of all, my lord, if I am not an accused, since the investigation is over and no complicity has been found against me, in that case, even if some person, because deposit is something which is not in my control, if my brother gets an amount deposited in my account, at best the IO could have got the bank to freeze that particular amount or put a lien on that amount. My bank account, I have a sole bank account, which I am using for my my sustenance and my business and everything. The freezing of the entire bank account causes prejudice to me when I am not even an accused in the case. And secondly, more importantly, my lord, page 47, I have given the bank statement for that relevant period. And there is no deposit of rupees 5 lakh rupees in my account.
And in the case diary, how much account is alleged to have been deposited
5
in,
lakh rupees
in your account?
in my account. And that amount is not there. Even otherwise, my lord, suppose because there are bits and pieces of small amounts are there, my lord. Even if it is assumed that those amounts are the amounts which was defrauded from the informant, what the IO could have done or the bank could have done was freeze only that particular amount. Unless and until I'm an accused in the case, keeping my entire account frozen, that is, my lord, prejudicial to me.
Yes. No, but perusal of the case diary may be required because
Whether
on,
this amount was even there.
yes, on what basis the IO has given that report. Merely saying it would not enough. There has to be some basis for IO to give report. So we'll call for the case.
This is charge sheet, so many scan copy. There is more money beyond.
Because investigation is complete. So IO must be knowing how much amount has been deposited to his account. Heard Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 438/450-42 of BNSS has been filed by the petitioner, namely Rashidul Islam, alias Muhammad Rashidul Islam, impugning the order dated 25/6/2025 and 2/8/2025 passed by learned SDJM Gosaigaon in PRC case number 73/2025 in connection with Gosaigaon PS case number 49/2025, whereby the prayer for defreezing of the bank account of the petitioner was rejected. Stop. Call for the scanned copy of the trial court records within bracket PRC case number 73/2025, as well as this scanned copy of the case diary of Gosaigaon PPS case number 49/2025. The registry to take steps for requisitioning the scanned copy. List this matter after
22nd or 25th.
Date fixed date. 22nd of
MDP.
21. May it please your lordship. Here, my lord, the impugned order is at page 27, your lordship. Here, my lord, my prayer for Jimma was rejected, my lord. Page 27 is the impugned order.
Jimma of the
Jimma of my vehicle, your lordship. The case is charge sheeted, my lord. I am not an accused in this case. Page 27, my lord. May I take your lordship to page 27, my lord?
yes.
My lord, may I read the order?
What is the offense?
Offense is, my lord, attempt to commit robbery. That is page 12, my lord. But what happened, my lord? My vehicle was taken by another person.
No, what is the offense?
My lord, offense was attempt to commit my lord, robbery, my lord.
Okay.
But not me, my lord. But other person, my lord. Page 27 is the, my lord, the impugned order. For 10 months, my lord, my vehicle is lying in the police station. Page 27, my lord.
On what ground the prayer was
But
rejected?
prayer was rejected by my lord because, my lord, whatever, my lord, I have given my vehicle to another person, my lord, Rekibul Hussain, my lord, to, my lord, entering into an agreement that he will, my lord, drive the vehicle, my lord. But he has and pay my remaining installment. That agreement I have annexed, my lord. But he has
What is your name?
My name is Qasim Ali.
But this Rekibul objected to grant of Jimma.
He now, my lord, he has objected. Now, my, why he has objected? Because it is a fact. He has given me 1,40,000 rupees, which I admitted. But later on, I have returned, my lord. then may I take your lordship to the affidavit now and he has filed, that is at page 33. It was at that time he has objected, my lord.
Then thereafter you should have again gone to the trial court.
But my lord, because my lord, it's a whether my lord we can go, my lord, because it was
Okay,
rejected.
okay.
Task rejected. But now my lord, now my lord, Jehrul has deposed, my lord, has filed an affidavit.
Where is that affidavit?
Page 34, my lord, the relevant portion. My lord, my vehicle is lying in the police station for 10 long months, my lord. And only thing it was rejected because this Jehrul, my lord, he has objected for granting me Jimma, my lord. Now, my lord, he has said that, my lord, and it's a charge sheet case, my lord. I am not an accused in the charge sheet. Only thing I have given my vehicle to Jehrul, my lord, and he has started the vehicle for using in immoral activities. That's why I have taken back the vehicle. I have returned him the money. Now, my lord, my vehicle is lying for 10 months in the police station. And here is the original affidavit also, my lord. And I'm, lordship knows, I am lying on Dasban of Sundarbai Ambala, my lord.
Where is that? Judge?
Then government. Okay.
Yes, yes.
My lord, in the page 28,
28.
my lord, at that point of time, Jehrul my lord objected, my lord. Page 28, para number 2, my lord, in view of the above, even though the Jimma petitioner is registered owner of the vehicle, however, he has already sold the vehicle to accused Zahirul Islam. Now, my lord, my lord, regarding that, my lord, the report may be confirmed for the.
I have got the original affidavit also, my lord. But at that time, there was a dispute, my lord. And it's a fact because he has started using my vehicle in immoral activity. That's why I have taken back the vehicle, returned him the money, what he owes. Now, my lord, the vehicle is mine, my lord. And it was rejected because, my lord.
No, where is the agreement by which you gave the vehicle to Jehrul?
Agreement, my lord, agreement. Agreement is at page 30.
That was agreement for sale.
But agreement for sale, my lord, though it is not valid, but my lord, we have entered into an agreement because it's the vehicle was still under hypothecation. So, my lord, 10 months, 10 long months, my vehicle is in, and only point it was rejected because Jehrul has objected. Now Jehrul has no objection, my lord. Now I'm keeping my vehicle, my lord, in police station. Now 10 long months.
Now, whether the vehicle registration has been changed in the name of
no, my lord, only agreement was there. Only agreement.
Where is the RC?
Because it has to be
RC, my lord, page 26.
But Jehrul is not before us.
But Jehrul cannot be, my lord, because because it's between the state and us, my lord, because Jehrul has not seized our vehicle. It is the police who has seized the vehicle. Now he has given an affidavit that he has no objection. And there is the original affidavit also, man.
If you are relying on affidavit, that original affidavit should have been there in
But
the
it may be kept as a part of the record, my lord. Now, and am I keeping 10 months in the police custody, my vehicle lying, facing heat, sun, rain?
heard Mr. S.M. Abdullah P, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS had been filed by the petitioner praying for impugning impugning the order dated 4/3/2025 passed by learned additional session judge Nogao in connection with sessions within bracket T2 case number 30/2025 arising out of Nogao PS case number 1110/2024 under section 310 within bracket 4/312 of BNS 2023. the facts relevant for consideration of the instant revision petition is that in connection with Nagaon PS case number 111110/2024, the 4-wheeler Boleno Alpha vehicle bearing registration number AS02 AA 8926 was seized. The acquisition in that case was made against one Jairul Islam and Raqibul Islam. Jairul Islam alias Raqibul Hussain. Stop. Charge sheet has been laid now.
Charge sheet has been laid.
Against?
Against my these 3%, my lord. That is a page, my lord. My name lottery will get a page 15 type copy.
In the aforesaid case, charge sheet, after completion of the investigation, charge sheet has been laid against 3 accused persons, namely Muhammad Habiz Bhuya, number 2, Muhammad Amir Hamza, number 3, Muhammad Zahirul Islam alias Raqibul Hussain. Learned counsel for the petitioner has submitted that the petitioner is the registered owner of the seized vehicle. To support his submission, he has produced a copy of the registration certificate of the seized vehicle, wherein the name of the present petitioner has been shown as the registered owner of the vehicle. Learned counsel for the petitioner further submits that the said vehicle, in respect of said vehicle, one agreement to sell was entered into between Zahirul Islam and the present petitioner. However, as the sale was not complete, the name of the petitioner continued to remain as owner in the registration certificate. Learned counsel for the petitioner submits that as the vehicle was found to be used in illegal activities, the petitioner cancelled the sale agreement and has returned back. How much money you have returned back?
140. 1,40,000.
1,40,000 to the said Zahirul Islam, with whom the agreement to sell in respect of the vehicle was entered into. Learned counsel for the petitioner submits that in the impugn order, the prayer for Jimma to the present petitioner, prayer for Jimma of the seized vehicle to the present petitioner was rejected mainly on the ground that the accused Zahirul Islam alias Raqibul Hussain had lodged an written objection. Written objection, and also on the ground that while executing the agreement to sell, the petitioner had received rupees 1,40,000 from said Jahirul Islam. Learned counsel for the petitioner submits that now the Jahirul Islam has been paid back the money, that is 1,40,000 by the present petitioner, and therefore said Jahirul Islam has sworn an affidavit which is submitted in this revision petition. Sworn an affidavit wherein he has stated that the dispute between the petitioner and said Jahirul Islam has been amicably settled, and he does not have any objection if the vehicle is given in Jimma to the present petitioner. A original copy of the said affidavit is produced by learned counsel for the petitioner. Same is marked as X and kept in the case record. Stop. I have heard learned counsel for both sides. It appears that the vehicle in question was seized on
My lord, on that 1911, my lord. 1911.
19/11/2024, and for last more than 10 months,
Yes.
where it is kept.
With the police station.
It has been kept in the police station under the open sky. Learned counsel for the petition under the open sky. Stop. Which para?
Paragraph 17, my lord.
In the case of Sundar Bhai Ambalal Desai versus State of Gujarat, reported in 2002, 10 SCC 283, the Apex Court has observed as follows. Court para 17 from the said judgment. Stop. In view of the above aforesaid observation, there is no dispute over the legal proposition that it is of no use to keep the seized vehicle in the police station for a long period, and the magistrate should pass appropriate orders immediately by taking appropriate bonds and guarantee as well as security for return of the said vehicle. In the instant case, by the impugned order, the prayer for Jimma was rejected mainly on the ground of objection lodged by the accused Jahirul Islam, to the effect that he has paid rupees 1,40,000 to the present petitioner. However, by filing the affidavit, which has been marked as X, the said Jahirul Islam has has stated that he has no objection if the vehicle is given in Burma to the petitioner. As the petitioner is the registered owner of the said vehicle, and as he is also not named as an accused in this case. Moreover, the vehicle in question has been kept under the open sky in the police station campus. this is a fit case where the impugn order has to be interfered with and the Jimma of the vehicle may be granted to the registered owner, that is the petitioner in this case. Accordingly, the impugn order is hereby set aside and the investigating officer of which police station?
Naga Police Station.
And the officer in charge of Naga Police Station is directed to give the Jimma of the vehicle bearing registration number AS 02AA 8926 to the present petitioner on his furnishing a bond of rupees. What is the cost of the vehicle?
New, it will cost 7-8 lakh, madam. New.
8 lakhs.
It is old, madam.
6
lakh, madam, because it is.
6 lakhs. Bond of rupees 6 lakhs. With an undertaking by the petitioner to produce the aforesaid vehicle as and when so required during the trial by the trial court. At the time of giving the Jimma, the investigating officer shall prepare a inventory of the seized vehicle and also take photographs from different angles of the seized vehicle. And after giving the Jimma, the bond, inventory and the photographs shall be sent to the trial court for keeping the same along with the records of the trial court. With above observation, this criminal revision petition, this criminal petition is hereby disposed of.
Oblige, your lord.
Item 22.
Petition praying for quashing.
Quashing
FIR
of-
and charge sheet. The allegation in the FIR is related to rape, Your Lordship. However, during the course of investigation, it is evident that no allegation, the allegations of rapes are not substantiated. Your Lordship. It was a consensual relationship and they stayed together due to a consensual relationship. Now, despite the unearthing of those facts, the police have submitted a charge sheet against me, and now I am supposed to face trial. So praying for your lordship's interference under section 528, we have filed this application. The FIR,
What is the stage of the trial?
it has not yet commenced, Your Lordship. First date is 26. I have not received the summons also. I have applied for the certified copy. Now I have one.
We are issuing for this. Issuing notice.
Lordship, stage, proceeding may be staged, Your Lordship,
No.
because the
It is a charge sheeted case.
Lordship,
So
but
some
the-
materials are there.
no, Your Lordship,
Your contention is that without those materials, the charge sheet has been filed.
Right.
So that has to be examined.
I have annexed the documents, Your Lordship. I have annexed the charge seizure list, Your Lordship will find page 35 and 36. Recorded only for a moment, Your Lordship will
What
find
is the statement of the victim?
statement of the victim, that is not with us, Your Lordship.
That is the most important thing.
That is there, but they have stayed in the hotel. She has submitted the Aadhaar card also in the reception. And also she has monetarily also she had funded the stay with the boy. Now she has alleged rape, Your Lordship. That I have taken her to an empty house and raped her. That is the.
That has to be examined.
Yes, Your Lordship. Only at this stage, Your Lordship,
No.
uh,
Heard Mr. Z.Z. Ahmed, learned counsel for the petitioner. Also heard Miss N. Das, learned additional public prosecutor. This application under section 528 of BMS has been filed by the petitioner, namely Bubul Kolita, who is praying for quashing of the proceedings of PRC case. What is the case number? Sessions case?
1866/2020.
Where have you mentioned?
Lordship, in the prayer portion, page 22,
Sessions case number.
page 21.
PRC case number 1866/2025, pending before the Court of Learned, SDGM number 2, Kamrup Metro. Let the scan copy of the records of PRC case number 1866/2025, as well as scan copy of the case diary of Ajara PS case number 181/2024 be called for from the trial court. Let also notice be issued to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by registered post with ID as well as by usual mode within 7 days from the date of this order, returnable on 23rd October, list accordingly.
Only some protection may be given, otherwise it will not take long, to decide this matter. Lordship may kindly examine the issue.
Let it come.
Lordship, on the next date, then interim order may kindly.
What interim order?
Also regarding stay, I have prayed for a stay of the proceeding.
Okay.
That will be.
Oh.
The next date.
The prayer for interim relief would be considered only after receipt of the scanned copy of the trial court records as well as case diary.
Much.
Yes.
May I plead your lordship, petition for quashing the interim order of issuing NBW. My lord, in this case, the informant's daughter, informant daughter participated in a marriage ceremony where the accused petitioner called her and taken her to the riverbank and forcefully committed sexual assault on her. She's is about 14 years. Because the petitioner has not received any summons.
Whether summons were issued?
Summons were issued, but he did not receive any summons. And police have investigated. He was at home till 2021.
You have been shown as an absconder.
Absconder. Yes.
You have annexed the copies of all orders. Where are the?
All orders I have 17 times. NBW issued for 17 times. And page number 25.
No, but the observation is summons issued to the accused was duly served. Page 25.
Someone issued to the accused was received late on the previous date, which was duly served. But he did not receive any summons.
But court is mentioning that
He was in Kerala.
When is the next date fixed?
Next date fixed for 23/9/2025.
What is the date of offense?
Offense under section.
Okay, you appear on 23/9.
Till then, I may be protected.
Okay, we'll stay the NBW till 23/9. Heard, Mr.
Yeah.
P.A. Ahmed, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner impugning the order dated 3/8/2024 and subsequent orders passed by the Court of Learned Special Judge Nalbari in Special POXO case number 34/2021, whereby non-bailable warrant of arrest was issued against the petitioner. Learned counsel for the petitioner has submitted that the petitioner has not received any summons as he was in Kerala for his livelihood. When you return, you have returned back?
He returned back, he was informed on 26/8/2025. He was informed by one of his friends that a case is running against you in Nalbari Special Court.
When you returned?
He returned 26.
Said date. Stop. On his appearance before the trial court, the petitioner may seek any relief before the said court to which he is legally entitled to. With above observation, this criminal petition is disposed of.
Item 24.
The petitioner is aggrieved by the non-consideration by the learned judicial magistrate. His petition for custody of the mobile phones which was seized, my lord, from the accused.
Mobile phone.
Mobile phones, my lord. So it was seized sometime in the month of April, my lord. Even thereafter, it has not been produced in the court. And my lord, that after Sundar Bhai and thereafter the division bench judgment of this court, which says that, my lord, if it is not produced in court, and thereafter the learned magistrate can, my lord, consider the release in Jimma. That has not been done, my lord, and the only, my lord, cryptic, my lord, reason that has been
Why it was not?
It was shown that, my lord, the IO has stated that it was required for investigation. That is why, my lord, he refused to.
When it was seized?
It was seized on 29/4/2025. Lordship finds that order at page 10, my lord.
Investigation is going on.
Yes, my lord. Investigation is going on.
Okay, case diary would be required.
Case diary
These
is here,
three
because,
are
my lord,
on
Case diary
bail.
is here because this, my lord, case, there are three bail petitions today, my lord. Item number 37, 38, and item number 1.
Today?
Yes, today. It was fixed today, my lord. And this relates to the same case diary. So this matter can be taken up along with, my lord, the item number 38 and 39 when, my lord, we are pressing for bail of the accused, my lord, in that case. Some of the accused were already enlarged on bail, my lord, but some others has been, my lord, now apprehended in that case, and we are, my lord, for them.
No, suppose if the mobile phone is required for investigation.
My lord. No, my lord, what is happening today, my lord, they can recover the data, my lord, and then they can hand over the phones, my lord. It is only the data, not the phones. Data they can recover and keep it, my lord. Because Sundarlal, my lord, so far as go release of money.
No, Sundarlal Ambabhai Desai may not come in this case. In this case, whether the requirement of mobile phone would be necessary
investigation.
In trial.
In the trial, the data would be necessary, not the phones by itself, my lord. What is the phone, my lord? Only the data. Let the IO keep the data and give me back my phone.
So. after
Okay,
all-
we'll take it up along with the said case. Case diary is there.
Your Lordship, we have to obtain certain instructions. The matter may be fixed after next week.
After,
Next week, Lordship.
after vacation,
Next week, Your Lordship.
next week, okay, it is motion. Mr. What is your name? R.
Karim.
R. Karim, learned counsel for the petitioner, who prays for an adjournment, as some instructions are required to be obtained from with regard to this case. The prayer is allowed. Let this matter be listed on a date to be fixed by registry.
27.
My plea, the Lord. Here is looking for quashing of the FIR as well as the sheet. The petitioner before your lordship, he was appointed in the year of 2021 as district resource person for social audit of various schemes, your lordship, such as Manrega, NSP and PMAY schemes. And he was posted at Hosai district. Respondent number 2, he was the block development officer of Dhalpukri development block. The FIR was lodged by the respondent number 2, that is at page 24, your lordship.
On what ground you are seeking?
There is no materials at all, your lordship. Herein the FIR was registered under section 420 of the IPC. But plain reading of the FIR, your lordship, I am reading the FIR.
No, but now we have crossed the FIR stage.
The ground herein is that, your lordship,
Yeah,
there is no prima facie case at all.
Charge sheet has
For
been,
I am reading the kindly, your lordship, page 24, your lordship, kindly.
yes,
Page 24.
yes.
It is respectfully inform you that I am the video of Dhalpukri block and the accused Mineral Islam is a district resource educator person, social audit. Sir, yesterday at evening at 6 p.m. the accused called me over phone to meet with me, but 6 p.m. was a breaking time of my duty. So at present, I cannot meet. However, I replied to meet me on the next day in my office. The accused told me to meet on the way near at Don Bosco school. I noticed him near at Don Bosco, but I could not found him. I had left. Later on, the accused made a complaint against me at Hosai police station that I have not cooperated with the meeting arranged by the accused along with some other allegations. Sir, I do not know anything about the meeting and no prior letter of meeting has been served to me. By way of misguiding, the accused has been sitting with me. Prior to it, there is allegation that the accused has seated with our staff in various ways. And on the basis of this FIR has been registered under section 420 of the IPC. And before it, your lordship, the annexer to your lordship, that FIR was lost by the present petitioner, your lordship.
Before that,
Annexer to your lordship, that FIR was lost by the present petitioner against the respondent number 2, your lordship.
then what is there in the charge sheet?
Charge sheet the same. Charge sheet is at page 30, your lordship. Page 30 and 33 is the relevant.
What is the acquisition?
Here in the acquisition of 420, your lordship, the charge sheet has been laid under section 420 of the IPC. Only the sufficient evidence except this nothing, your lordship. In the FIR as well as the charge sheet, only that line is there that misguiding the accused has been sitting with the complainant. Only this much, your lordship. Except if there is no any time, date, nothing, your lordship, or delivery of.
heard Mr. A.M. A.M. Khan, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. This application under section 528, cognizance has been taken.
Cognizance has been taken and the next date is 26/9/2025 for appearance.
528 of BNSS filed by the petitioner Minarul Islam, praying for quashing of the proceedings of PRC case number 171/2024 pending before the Chief Judicial Magistrate, Ojai. Learned counsel for the petitioner has submitted that in the aforesaid case was initiated on the basis of an FIR lodged by respondent number 2 on 27/5/2022.
No, 25/5
On
25/5/2022.
where is, you have mentioned it,
24 year lordship. Case 27 year lordship. The vernacular one, case 24.
which one is the affair?
Case 27.
24.
Case 27 is there.
Okay, 25/5/2022. Wherein the only accusation made against the petitioner is that without informing anything about the, what meeting is he's telling about?
Meeting means actually the meeting, the deputy commissioner is the authorized person to organize the meeting, your lordship.
What meeting?
For social audit. For social audit of the schemes, your lordship, like Manrega, NSP.
Directly. Petitioner that without informing anything about the informant regarding meeting in connection with social audit of government schemes, the informant was asked to meet the present petitioner and thereby he had cheated her. Learned counsel for the petitioner submits that on bare perusal of the affair, it would reveal that no ingredients of section 420 of IPC has even been mentioned in the affair. He further submits that even in the charge sheet, apart from mentioning that sufficient materials against the petitioner are there under section 420 of IPC, nothing has been stated therein which would indicate presence of any ingredient of the offense under section 420 of IPC. I have considered the submissions made by learned counsel for both sides. Issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 within 3 days from the date of this order, returnable on 23rd of October. Stop. However, in the meanwhile, as prima facie on perusal of the FIR as well as as well as charge sheet, this court is unable to comprehend any ingredient of section 420 of the Indian Penal Code therein, further proceeding of PRC case number
171/2000.
171/2024 pending before the Court of Learned Chief Judicial Magistrate Ojai shall remain stayed till next returnable date, list accordingly.
Public.
May I please, Your Lord?
Yes.
The prisoner before Lordship, my lord, he was an informant, my lord. What happened? He lost an FIR against the one under section 156(3), my lord. That FIR you will also find at page 15, my lord. Basic allegation is that his wife and daughter here, they have not good terms, my lord. They're living separately. And they forged the documents, my lord. And where his name was changed, my lord, to Fukon, my lord. Actually, it's Hyder Ali. Hyder Ali Fukon was added in his documents, my lord. And they have obtained the admit card as well as admit card of the daughter, my lord. And accordingly, he lost the FIR, my lord, on 156(3). That was registered, my lord. And it was registered under section 365, 466, 420 IPC, my lord. And after finally, charge sheet was submitted, my lord. But no offense was found, no offense under only 294/506, my lord. So he made an application before the Learned Judicial Magistrate, my lord, for further investigation. And the Learned Judicial Magistrate, your lordship will find, your lord, after on going through the case diary, my lord, has come to a finding that your lordship will find in page 40, my lord. Page 40. There, your lordship, from the case diary, it appears that the investigating officer has recorded a statement of 4 witnesses, 180 BNSS, including the informant. Statement of witnesses number 4. The concerned register office of the Birth and Date Registration Department, Department of Health Services under Kakodan PHE, witness number 5, and Principal Jyoti Vidyapith District, Jorat, as mentioned by the complainant in his complaint petition number so and so, were not recorded. Documents relied by the informant, as mentioned in the list of documents in the complaint case, were neither seized nor verified by the investigating officer. Having scrutinized all the facts and circumstances of the case, on satisfactory grounds warranting further investigation of the case are found. Therefore, I found it prudent to direct the officer in charge of York Police Station to conduct further investigation of the case in terms of section 173(8) of the CRPC under 193(9) of the BNSS. Accordingly, officer in charge of York Police Station directed to conduct further investigation of the case so and so, submit a report in terms of the provision so and so, send the case died. Now what happened? This order was challenged because before sending the for further investigation, the informant was also, the accused person were also hard on this point, my lord. On being agreed by this order, my lord, they moved an application before the session judge under criminal division 399 and 397. That is under new section 438 and 440 of BNSS, my lord. There they have taken the point, my lord, that this petitioner knew about the occurrence way back in 2015. So there was delay. On the ground of delay, my lord, that court finding your lordship may kindly come to my, whether that is permissible by revision court or not. That your lordship. Your lordship.
Page number?
Page number, discussion, page 48, my lord. The impugn order dated is connection paragraph 10, my lord. In connection with petition number is passed in connection with so and so is required to be examined for correctness, legality, and propriety. Learned person of revision has vehemently submitted during the hearing of the complainant as well as verse of change of so and so in order dated so. As you are silent in regard to till June 2004, in title suit number 7 of 2000, our alleged accused was none other than their wife and daughter as complainant and complainant the title case number so and so before the court of Munshi seeking divorce from the accused number 1 from the year 2000. Benson, his name has been changed from Hyder Ali to Hyder Ali Fugon. I've also perused the attested copy of the judgment dated so and so, and complainant due love and affection had honored certain property to accused number 2. He has also knowledge about the change his name so and so in the admit and registration copy of the accused. More learned counsel would have revisionist gave state since the complainant knew about the facts of changing of name. Since 2000, now at this belated stage, complainant raised objection for some ulterior purpose. Underline the counsel for the respondent doing investigation giving states, let the root come out by further investigation of the case and it is not be cause prejudice to the accused as the investigation was not proper. The claim of the nature of forgery as well cheating, the IO did not conduct proper investigation. Then you will also find he has, the council reported some decisions of the Supreme Court were also relied upon, my lord. And finally, there is that decision was mainly regarding the further investigation warranted hands of investigation should be tied down to ground of further delay the trial. Ultimate is to arrive at truth so and so. Then on the ground of delay point, my lord, they have are before that court, my lord. That paragraphs 20, my lord. And the prime question before the court is that whether the order of further investigation of the case is illegal, incorrect, improper, or irregular. In my considered view, since the complainant knew about the changing of Hyder Ali to Hyder Ali Fugon since the beginning of 2015, he was sleeping till to June 2024. Subsequently, the complaint was came forward to further investigate the complaint under 428, 468. There is no change of any explanation provided by complainant why he remained silent for so prolonged period. Apex Court has clearly mentioned that inordinate delay may be condoned if a fair trial demands, but unexplained inordinate delay may be taken into consideration while passing an order for further investigation. In this case, the complainant has not made any whisper about such inordinate delay, and complaint conduct doesn't appear to be fair to this court to allow further investigation. I find that the impugn order was passed without taking into consideration of the fact that such inordinate delay without explanation. The trial court passed the order of further investigation warrant interference accordingly. Now, my question before your lordship, my lord. It is a their exercising power under section 397, 399, a revision court. Revision court is confined to the legality and validity of the order. Now, the accused persons have their point out that there is a delay, my lord. Knowing fully well, delay has not been explained while filing the application on the 150. Delay is a question of trial, my lord. When the investigating officer failed to investigate the case, there was no seizure of the documents, my lord. So, Learned Mason acted upon accordingly. There was no investigation. Had there been investigation, matter would have been different. Now, whether the revision court can go into that matter regarding delay point. When the Learned Mason has correctly passed an order that there was no investigation, it ought to have been investigated. There was no seizure, nothing. In spite of the fact, it was case as a result.
Is there any limitation in offences under?
No, 427 years, more than 7 years. Okay. 468 is 7 years. So where is the question of limitation, my? So my that is he exceeded the jurisdiction, my lord. He cannot go beyond that order, my. Your lordship, that order which is under revision, he cannot go beyond order. He has taken into grounds on titles to the these are not factors, cannot be taken into consideration while passing in order of revision, my.
Yes.
But
we have to hear the.
I understand, my lord. I'm not talking because in effect there is sort of your lordship also knows it very well that revision court has confined to the correctness of the legality and propriety of findings and sentence of the order, my. Whether that order is legally passed or not. Because he has found on case diary, the Learned Mason, on perusal case diary, he found that there was no investigation regarding the forgery. And that was the contents of the FIR. Okay. That's why he further investigated.
Okay, we'll issue notice.
So he has exceeded the without jurisdiction, my submission. The Learned Revision Court has crossed the jurisdiction, my. Without jurisdiction, he has come to finding that cannot be argued at the point of that during course of investigation, that was delay, my. It's a question of trial. And the decisions he has taken today, these are all trial cases. The trial has yet to commence here. It's better relating to investigation. Okay. No seizure has taken place.
Okay. Heard Mr. P. Kotoki, Learned Counsel for the petitioner. Also heard Ms. M. Das, Learned Additional Public Prosecutor. This application has been filed under Section 528 of BNSS 2023 by Muhammad Hyder Ali, impugning the order dated 28/8/2025 passed by the Court of Learned Additional Session Judge Jorhat in Criminal Division number 16/2025. Mm. 16/20. This is maintainable 528.
Yes, 482 my lord. Maintainable.
16/2025. Whereby it has set aside the order dated 14/5/2025 passed by learned Judicial Magistrate First Class Jorhat in PRC case number 489/2024, where further investigation was allowed under section 193 within bracket 9 of BNSS. Issue notice to the respondent number 2 and 3 and call for the records of criminal division number 16/2025 from the Court of Learned, Sessions Judge Jorhat. The petitioner shall take steps for issuance of notice upon the respondent number 2 and 3 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 23rd of October.
I'm praying for stay, my lord.
Stay off.
Impugn order.
Then it will automatically the investigation will start. Before that, the objector has to,
Or interim prayer, my notice may be.
the prayer for interim relief of the sought for by the petitioner shall be considered after due service of notice on respondent number 2 and 3. Used accordingly. For for reasons mentioned in the judgment, this criminal revision petition is dismissed.
Item 29.
Yes.
May I please, Your Lordship? Only an application order 528 for quashing the criminal proceeding number 5 PSC number 419/2024 under section 406 and 420 of IPC which is pending before the judicial magistrate first class at Boko, Kamrup. In this case, two number of petitioner petitioner number 1 and petitioner 2 are the relation own brother Petitioner 1 and 2 are the own brothers by relation
At what stage it is pending?
Hello?
What stage?
Appearing.
When is the date?
My lord, there's a 4/11/2025, my lord.
We are issuing notice.
My lord, no, my lord. This number 2 is the informant, my lord. This petition has been jointly, my lord, for quashing, my lord. And in the May, my lord, this fact, my lord, is that, my lord. My lord, petition number 1 took amount of 7 lakhs from the petition number 2.
No, we will require the charge sheet and the document.
In the meantime, my lord,
We will fix it before next date. Heard Mr. S. Rahman, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 528 of BNSS has been filed jointly by the petitioners, namely Daiver Ali, alias Driver Ali, and Moinul Haq. The petition number 1, and Moinul Haq, praying for quashing of the criminal proceedings of PRC case number 419/2024, pending before the Court of Learned First Class Judicial Magistrate, Boko, Judicial Magistrate First Class, Boko, under section 406/420. Learned counsel for the petitioner submits that the petitioner number 1 is the accused And the petitioner number 2 is the informant in the said case,
Both are own brother.
and both are own brothers. Let the scanned copy of the records of the trial court as well as charge sheet, scanned copy of the case diary be called for. Registry to issue, take steps for requisitioning the scanned copy. List this matter. When is the next date?
4/11/2025.
Before 4/11. 27th October. No, 27 October.
College. Last one, Lordship, status report was called for, Lordship, and status report was received, Lordship.
Status report has been received.
Received, Lordship. It is in the
Status
separate
report
file,
now.
Lordship.
Overall. Oru,
Status report, Lordship, another 2 witnesses examined, Lordship.
Oru. Now.
Next date is fixed on, Lordship, day after tomorrow, Lordship, that is 20/09/25.
Itu this status report is of 23 latest control. You have gone through the status report
The certified copies of the last order, Lordship, as well as last depositions,
and the status report. You have gone through the status report.
Lordship, it is there, Lordship.
So you can. Itu dioksin. Itu diok. That is 27/9/2023.
Lordship.
It is 2023. So is it a typographical mistake or?
Probably, Lordship, typographical mistake. But, Lordship, in my certified copy, Lordship, next date is fixed on 20/09/20.
20?
09, Lordship.
But
Day after
the
tomorrow.
status report, it says 27/9. So that is not the status.
Lordship, in the office note, Lordship, it is there, Lordship. There is the
Wrongly
report is-
mentioned.
Lordship, it was received on 5th September, Lordship, 2025.
Betul.
I have the certified copy, Lord.
Certified copy of,
Position as well as last order, after rejection of this higher
Yes.
application.
yes, what is your submission?
Okay, here in this case, may I place some important state, Lordship? In this case, Lordship, FIR was filed on 28/7/2022, Lord.
28/7,
2022, 28/7/2022. And Lordship, he was arrested on 4/9/2022. And as on today, Lordship, 3 years, 6 days, Lordship. And charge sheet filed on Lordship, 17/1/2023, Lord. 17/1/23 charge sheet filed and charge framed on 27/7/2023. And Lordship, his last bail application was rejected on 4/3/2025. At page 100, Lordship. And last witness, Lordship. In this case, Lordship, PW 19 examined on 5/10/2024. And
yes,
Lordship, PW 20 and 21 examined on 27/6/2025. After about 8 months, Lordship.
PW,
PW 20 and 21. 27/6/2025 and next date fixed on Lordship 20/09/2025. Lordship, I have the order sheet also there.
now why it was rejected at the,
Lordship, in this case, Lordship, total 15 persons are there, Lordship.
how many?
15 persons, Lordship.
15
15 persons
accused,
accused, Lordship. And
okay,
out of 15, Lordship, 13 persons already got bail, Lordship.
on what ground?
Lordship, I have annexed all the orders.
Why your prayer was rejected?
Lordship, last rejection order, Lordship, page 98, Lordship.
When it was last rejected? 4/3,
4/3/25, page 98, Lordship.
6 months.
I am not the FIR named accused, Lordship. FIR named accused is Lordship already got bail, Lordship.
What is the accusation against you?
Lordship, acquisition page 18, Lordship. FIR, Lordship, page 18. The relevant page, Lordship, page 22, Lordship. 9 persons are, 8 persons named in the FIR, Lordship. I am not named the FIR.
Yes, Mr. Sharma.
Sure, I am only on delay in trial, Lordship, because there is a 56 witnesses there.
Out of 15, 13 are already on bail.
Yes. Lordship, the role of the accused has to be seen, Lordship. In
Yes.
matters of serious offences, Lordship, penalty cannot be a grant. Here, Lordship, the petitioner's allegation, Lordship, will find in the charge sheet at page number, Lordship, on the yes, page number 68.
Page 75. Page 75.
Page 68,
69, Lordship, sorry,
page number?
69.
Yes,
This is the type copy, Lordship. This is the allegation against the present petitioner, Lordship.
yes.
Your Lordship, he has been alleged to be sheltering, giving financial aid, and aiding in all these activities, Lordship. In a gist, Lordship.
No, read, please read.
Mamunur Rashid so-and-so is the member of ABT member of Sarifur Islam, Hamidul Islam, so-and-so at his he appointed Aminul Islam as Imam of Thokiela Para Masjid as Arabic teacher of the madrasa. He also appointed ABT member Mehbur Rahman as Arabic teacher at his Thokolipara madrasa. He knows that all the ABT members are Bangladeshi national advancing the place. Lordship, they have skipped the portion, I don't know. He allowed these people to use his madrasa as a base at the ABT Equis to Borpeta. He gradually radicalized and voluntarily become a member of ABT AQIS. As member of ABT, he welcomed all ABT members and provided accommodation to them at his madrasa. He visited various dharma sova along with ABT members and fully helped them as ABT and joining new members to ABT. He also helped ABT members to transfer money through his SBI account for organizational work of ABT. He allowed members to-
And what was the accusation against those accused who are released on bail?
Their lordship, bail order, lordship will find different, it varies, lordship. From 106, it starts, lordship. In the charge sheet also, lordship, the role of the accused has been mentioned by name, lordship. Different accused, different role, lordship. In the charge sheet itself, it is present. From page, lordship will kindly come to the charge sheet. Page, it will start from, lordship, page 62. Altogether 15.
62.
62. You also will find down below Rafiqul Islam. Then 63 lordship, the other accused name will appear Diwan Hamidul Islam. His allegation is there. Moinul Haq, the allegation is there. So every accused has different role, lordship.
But allegations are more or less of similar nature.
No, lordship, it cannot be said similar, lordship. Everybody had a different role, lordship. He was more in, lordship, giving logistic support and financial support as well as sheltering, lordship. So that was a bit different, lordship, in my respectful submission. And that apart, lordship, it was earlier rejected by the coordinate bench. And lordship, now, if lordship kindly permits me to place this Watali judgment, lordship, a specific paragraph I will have to read out. I'm skipping the other portions, lordship, just one paragraph I will have to read, lordship. Yes, paragraph number 26. Paragraph number 26, if lordship kindly goes through.
Yes.
My paragraph may be different, lordship, but my paragraph will be different, lordship, because
Be it noted
yes, yes,
that special provision
yes, lordship.
Okay, I'll go through it.
Yes, Lordship, what it states, Lordship, is that once charge sheet is filed or charges is framed, Lordship, the burden shifts to them, Lordship, to show from the materials that they are not associated with the crime. Lordship. So that they have to discharge that part, Lordship.
Because of the embargo of
Yes.
section 40 D.
Yes, Lordship. And that apart, Lordship, here the petitioner, Lordship, he has already been convicted in another NIA case, Lordship. That is, that Lordship will find at page, he has already been convicted, Lordship, at page 34.
Page 34.
Page 25, it starts from page 25, annexure 2.
What was?
He has been convicted under 120B IPC and section 20, 30, 38, 39 of UAPA Act.
And you are undergoing sentence.
That also has to be taken into consideration by the Lordship, apart from the embargo, Lordship.
Already served, Lordship. In earlier case, Lordship, we already served this sentence.
So, completed. Okay.
That is my expectation.
Okay.
Lordship may peruse to page 113, Lordship. Kindly, Lordship, page 113, Lordship. His bail prayer earlier, bail prayer was rejected. Subsequently, he reviewed his prayer and he got bail, Lordship. Page 113, paragraph 4, Lordship. And Lordship, may I place one judgment, Lordship? Earlier occasion, Lordship, the prosecution side, Lordship, relied one judgment, Lordship. That is in the record, Lordship.
What judgment?
That Gurvinder Singh, Lordship.
Joginder.
Gurvinder Singh, Lordship.
Yes.
They relied. But subsequently, Lordship, the Honorable Apex Court, Lordship, distinguished that judgment, Lordship. Case, Lordship.
What it says?
That says, Lordship, the bail rejection in UAPA case, Lordship, rejection of bail is a rule, Lordship. Bail rejection is a rule, Lordship, and is a bail is
No,
accepted.
there is an embargo under section 43 D5. And your submission is that due to prolonged incarceration that
Only on 21, Article 21. On that count, Lordship, may I place one judgment?
Yes.
Paragraph 22, Lordship. Starts from 22, Lordship.
Yes.
Article 21 discuss, Lordship, paragraph 22. May I read, Lordship?
Okay, I'll go through it.
And Lordship, Gurvinder Singh, Lordship, discussed on paragraph 31 and 32, Lordship. Paragraph 31, 32.
Heard Mr. I.U. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section. No, let me reserve. I'll go through it and let this matter be listed for delivery of orders on Tuesday. Tuesday is 23rd.
Lordship, in the Lordship, there are 15 FIR name accused, Lordship, and out of 15 Lordship, some are convicted, Lordship, along with that appellant.
Some are
Already convicted, Lordship.
in this case.
No, Lordship, earlier case, Lordship.
Okay. You give me the list. How many are convicted? 13 are on bail.
Out of 13, Lordship, there are some of the convicted, Lordship. Petitioner along with others.
Okay. Give me that list. On 23rd.
DP of them.
Separate file of Yes, Pilapur.
36.
My application. The regular bail action considered case trial is going on in the present stage is the evidence stage, my lord. My lord, in this case, my lord, the prisoner was arrested, my lord, 22/8/2023, my lord.
22?
22/8/2023, my lord. More than 2 years, my lord, behind the bar, sir. Another government, my lord, and it's the page number 40, my lord. Page number 40.
What is the offense? 20B to C.
20B, C. In this case, there are the total accused 2 persons, my lord. One already granted bail, my lord. Namely Sangeeta Devi.
Page number?
I have not annexed here, my lord.
She was granted bail on humanitarian ground, Lordship, for some operation had to be done, so she was granted bail.
And my lord, total recovery, my lord, 23.99 kg only, my lord, from the 2 persons, my lord. Ganja.
And how many witnesses are there?
But, total witness are there, my lord, 10%, my lord.
How many have been examined?
I have no idea, my lord, because another council is engaged. Trial court, but as per report, my lord,
As per record, Lordship, one probably.
only one. Out of 10, my lord, only one witness.
Yes, prolonged incarceration is there. Heard Mr. S. Rahman done a counsel for the petitioner.
Just one
Oh.
submission, Lordship. The other petitioner was granted bail, Lordship, on
On
some
human-
condition, Lordship. The same condition we granted imposed, Lordship, because both
Where-
of them are from outside Assam.
Where is the?
That
oh,
Lordship is in the scan copy. I have flag mark, Lordship, order dated 7/4/25.
Total sound.
Only condition is, Lordship, 1 lakh rupees and 2 sureties. One should be a government servant.
Okay. Okay.
This may be
Heard Mr. B.
Lordship, the other petitioner is not appearing, Lordship. The
B.
other accused. That
Is
is
not appearing.
For last 3 or 4 occasions, continuously she is defaulted, Lordship. So
Also heard Mr. B. Sharma, an additional public prosecutor. This application, so this application under section 483 of BNSS has been filed by the petitioner. You have flagged it.
yes. I mean, 1 second, please.
By one Rani Devi, who has been detained behind the bars since 22/8/2023, within bracket for more than 2 years, in connection with NDPS case number 69/2024 under section 20B2C/29 of NDPS Act 1985. The gist of accusation in this case is that on 23/8/2000 on 22/8/2023, one Madhav Ekka had lodged an FIR before the officer in charge of GRPS, inter alia, alleging that that on receipt of an information through reliable sources, a joint checking was conducted.
Lordship has earlier rejected the bail application. So
Where?
at page 37.
Yes,
So that can be.
no, gist of accusation, court para 3 from page 37. quote para 4 from page 37. Learned counsel for the petitioner has submitted that the petitioner is seeking bail mainly on the ground of violation of the fundamental rights of the petitioner guaranteed to her under Article 21 of the Constitution of India on account of prolonged incarceration. He submits that the co-accused Sangeeta, co-accused one Sangeeta has already been granted bail. Sangeeta Devi has already been granted bail on account of her ailment. He also submits that till date, out of 10 listed prosecution witnesses, only one has been examined. He further submits that the petitioner is ready to face the trial, and hence she may be allowed to go on bail. On the other hand, learned additional public prosecutor has submitted that has opposed the grant of bail on the ground that the contraband involved in this, the quantity of contraband seized in this case is of commercial quantity, and therefore embargo of section 37 of the NDPS Act would be applicable. He also submits that the co-accused was granted bail mainly due to the fact that she was suffering from an eye ailment, and therefore on humanitarian ground her bail was allowed. So I have considered the submissions made by learned counsel for both sides. The apex court has in various of its rulings has observed that in case of prolonged incarceration in connection with an offense where commercial quantity of contraband is involved, the prolonged incarceration overrides the embargo of section 37 of the NDPS Act. In the instant case also, this court is of considered opinion that the incarceration of more than 2 years by the petitioner, who is a lady, that too when only one of the listed prosecution witness has been examined till date, would amount to infringement of her fundamental right guaranteed to her under Article 21 of the Constitution of India. And on that count, she is entitled to get bail. So, for the reasons stated herein above, the above named petitioner is allowed to go on bail of rupees 1 lakh with 2 sureties of like amount, one of whom should be a resident of state of Assam, with following conditions, trial conditions. This bail application is accordingly disposed of.
37.
May I please your lordship? The petitioner before your lordship, my lord, he has been arrested, my lord, on
37, 38, same, my lord. Which one and
on 9th of August, my lord. And since then, my lord, he is in. My lord, the basic fact is that this is a poor, my lord, Naga boy who had come to Guwahati in search of work, my lord, and he works in a kitchen as a cook, my lord. Neither has he been, my lord, named in this FIR. And my lord, he has been apprehended just because, my lord, there are 2 other people, my lord, who have been apprehended, and my lord, they found the phone number of this guy in their phones, my lord. And it is only on that basis, my lord, he has been arrested, and now, my lord, today it is 43 days approximately being in custody, my lord. There is, my lord, no, my lord, prayer for remand. And, my lord, in a similar occasion, in the same case, my lord, 3 of their friends, my lord, they were arrested earlier, my lord. And thereafter, my lord, they had been released on bail, and the, my lord, lordship finds, my lord, that order at page, my lord, 35. Take care, dear.
Granted bail by whom?
By this honorable court, my lord.
35.
My lord,
35 is not that
no, my
old.
lord, page number. Oh, it is not NH, my lord. I'm sorry, my son, component.
Where is the FIR?
FIR, your lordship finds at page, my lord, 16, my lord. Starts from page 16, my lord. That's where FIR is at page 20, my lord. May I place it, my lord?
You're named in the FIR.
No, I am not named in the FIR.
Where is your forwarding?
My forwarding report, my lord, is at page, my lord, 29.
Yes, what is your submission?
The submission is that, my lord, these are people who are not at all involved in these activities which they are alleged to have, my lord, being involved in, my lord.
Is there
My lord,
any
the
embargo?
allegation is the lordship, my lord.
Is there any embargo? 43D is a
Pardon, my lord.
embargo is 43D5 is
Yes,
applicable.
my lord.
Applicable.
Yes, my lord. It is not applicable. That is not applicable because of the fact that, my lord, there is nothing on record to join these people with the commission of any offense of this nature, my lord, under the
No,
UAPA.
okay,
10 and 13.
10 and 13. So it is outside the scope of 43D.
Yes, my lord. It's outside the scope of section 43, my lord.
Okay. Yes,
So when it is
Mr.
outside the scope of section 43 and there is no evidence to the record that they have, my lord, as far as this accused goes, that, my lord, he has committed certain offences, my lord, which that it is alleged to have been, my lord, either with the alpha or with somebody else. There is nothing on record, my lord. My lord, today what happens is just because, my lord, these people, my lord, have this tribal facial outlook and all, my lord, they just pick up and, my lord, put behind bars. Now kindly see, my lord, an attempt was made, my lord, for the purpose of, my lord, taking him into custody, my lord. That was, my lord, refused by the learned court below, my lord, on technical grounds. Thereafter, there was no prayer at all, my lord. My lord, that shows that, my lord, this is not there. Because had they been, my lord, definitely, my lord, connected to the any activity of the alpha, my lord, he would have been taken into custody, my lord, and, my lord, interrogations would have been committed, my lord, to ascertain as to who all were with him, my lord, or who with whom he was related or linked, or what sort of activities they were planning. There is nothing of the sort, my lord. Just picked him up, put him in the jail, and this poor guy is languishing there, my lord. People are there in Nagaland, nobody there to look after him, nobody here to inquire, my lord. And that is how this entire thing goes, and he is behind bars since last 42 days, my lord. This is my humble submission, my lord. And these will be considered, my lord.
Yes.
Okay.
My lord, yes, in this case, till now, my lord, 18 persons were arrested, my lord. Few were granted bail and few were rejected by this court also, my lord. Now, regarding, my lord, accusation of against all are not similar. Accusation of all are not similar. Now, and the statement, my lord, senior has stated that all the, my lord, tribal facing people, thousands of people are roaming around from Nagaland, my lord, all are not arrested, my lord. Now, fact is that, my lord, yes, two persons, first that item number 1 and item number 38. We are in item 37, but that two persons, they were, the two petitioners, they were engaging in a Naga kitchen, 6 mile area. And petitioner in item number 38, that person using the mobile number, that same mobile number, that same EMI number is of James Assam. James Assam used that mobile. James Assam is a veteran Alpha Kedar he used that mobile phone. Subsequently, that mobile phone came to the hand of that petitioner and item number 38. Now, role of the this petitioner, item 37, he brought those two boys from Nagaland, eastern village of Nagaland, is border, Myanmar border, From that place, this petitioner brought those two boys to Guwahati and engaged in Naga kitchen as a meat cutter. Now, fact is that they were linked with NSCN, Angami group also, and they in their statement also they have mentioned that one mobile number has been given. That person, I am not disclosing the name in the CD. That person asked them to come to Guwahati, and they were working in the Naga kitchen and waiting for any further instruction of that person. And accusation against this petitioner is that he, without verifying any document, brought those two persons to Guwahati. But that two persons, one person I have stated, that one person.
So accusation against him is
against him is he brought those two persons from eastern village of Nagaland and engaged in, as he already in that Naga kitchen, he is already in that restaurant. He engaged that two persons also in Naga kitchen. So accusation against this person is he brought those two persons to Nagaland, to the Naga kitchen, Guwahati.
Only this much.
He replied to what he said.
What are the names of those two persons?
Those two persons are petitioner in item 38 and petitioner in item number 1. And petitioner in item 38, there are materials. He using the same EMI mobile SIM may be changed. If one SIM is once used in a mobile and subsequently change it, then whenever any different SIM will connect in that mobile, that EMI number will come. The same EMI number matches with the SIM which is used by James Assam, and same handset used by this person. So they already stated in the statement that they have linked with one NSCN Angami group and one person group leader. They stated told him as a group leader. Materials are there that they send them before 2 months earlier to this 15 August. They send him to Assam, and they are waiting for further instruction. And they are working in that Naga kitchen. They be first picked up an accusation against this person. He brought that person.
Heard Mr. G. Chaudhary, Dalit counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioners, namely Oang Konyak, who has been detained behind the bars since 9/8/2025. How much is the punishment for 10 and 13?
Punishment is for 10 and 13.
9/7/2009. 9/8.
7 years. 2 years and 7 years.
Verified.
But this is the book. I have the book.
In connection with crime branch PS case number. No. Crime branch PS case number
It is 7 years, my lord.
2/2025 under section 61 within bracket 2/147/308 within bracket 2 of BNS, read with section 10/13 of Unlawful Activities Prevention Act. The gist of accusation in this case is that on 29/4/2025, one Dr. Shankar Jyoti Nath, Inspector of Police, had lodged an FIR before the officer in charge of Crime Branch Police Station, inter alia, alleging that and information was received through reliable sources that certain overground workers or linkmen of the proscribed organization Alpha Independent were found doing their operational activities in Guwahati. It is also alleged in the FIR that the said overground workers were directly associated to self-styled commander of Alpha I, namely James Assam, and are reportedly engaged in collection of funds through extortion. It is also stated therein that the FIR also named 3 accused persons, namely Y. Nemka, number 2 Yaman Konyat, and number 3 Hangmei Konyat. Stop. Learned counsel for the petitioner has submitted that the petitioner is an innocent Naga person who is presently employed in Naga kitchen and is in no way involved in the offense alleged in the FIR. Stop. He, however, submits that the petitioner has been detained behind the bars for last 43 days. And considering the fact that the accusation against the petitioners are mainly under section 10/13 of the Unlawful Activities Prevention Act, they may be allowed to go on bail. He may be allowed to go on bail.
My lord, my further submission, if I may say, my lord, is that, my lord, my petitioner, he belonged to, my lord, the same place where these were there. They all grew up together. So, my lord, they were unemployed. They wanted some work. I had knowledge that in my own establishment there was some work. That is how I brought them there. Nothing more than that.
This you thought now, or?
No. No, it was there all along because I told my lord.
You have not submitted earlier.
My lord, I did not tell it at that point of time because he was submitting. That is why I did not tell my lord.
Okay.
It was
Learned counsel for the petitioner has also submitted that in the meanwhile, the named accused in the FIR have already been granted bail by the coordinate bench of this court. He further submits that the other 2 accused persons, namely Longsha Nokan, alias Longshan Konyak, and what is the other side? And other accused and Akai Konyak. hails from his village, and therefore he brought them to work in Naga kitchen at Guwahati. Item number?
1.
Item number 1. Accused in item number 1. Stop. On the other hand, learned additional public prosecutor has produced the case diary of bail application number 2858. No, case diary of crime branch PS case number 02/2025, and has submitted that there are materials against the petitioner in the case record. He submits that he had brought the other two co-accused persons from a remote village in the eastern part of Nagaland to work in Naga kitchen, where they came in contact with the
He brought,
yes,
shelter in.
Naga kitchen. Stop. I have considered the submissions made by learned counsel for the both the parties and have gone through the case diary. It appears that the named accused in the FIR have already been released on bail by a coordinate bench of this court on 18/6/2025 in bail application number 1895/2025. It also appears that the only accusation against the present petitioner is that he brought the co-accused persons to work at Naga kitchen, and later on they were found in associating with the later on they were found having links with the proscribed Alpha I organization. Stop. Considering the nature of accusation as well as period of detention undergone by the present petitioner, also considering the fact in the meanwhile named accused have already been accused named in the FIR have already been released on bail, this court is of considered opinion that if the petitioner cooperates in the investigation, his further custodial detention may not be necessary for fair completion of investigation in crime branch PS case number 2/2025. Stop. Accordingly, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned
CGM Kamrup.
Chief Judicial Magistrate, Kamrup Metro. CGM, or it is before Special Judge?
Special Judge Kamrup.
Special Judge Kamrup Metro. This bail application is,
My lord, district and session judge is the.
he is the Special Judge. He is the Special Judge.
He is the special. I'm developed.
This bail application is accordingly disposed.
I'm developed. My lord, I'll
Condition
come
1
back once more, my lord, with the Jima petition, my lord. After my lord, he completes my lord.
Okay.
That is item number 24, my lord.
Item 1.
Last occasion, my lord was pleased to refer the matter to the district and session judge for confirming the age. The age of the accused has been recorded as 21 by the investigating officer when he's actually 17. So we had produced certain documents as to the age, my lord, which was
No,
given.
but age inquiry is going on by.
I would have to add something, my lord. The
Yes.
documents submitted by us were issued by the village council and the ANC in Cognac, there's a person who's the leader called the Ang. So under Article 371A of the Constitution, these have a special place because otherwise the Act specifies for the Gaon Panchayat. So the
No,
district and session judge, my
Mr.
lord,
Goswami,
Chaudhary, my lord.
Chaudhary.
We are all Chaudhary.
Okay, okay.
My lord.
The inquiry regarding age, ascertaining age is going on, is being conducted by the,
I was bringing my lordship up to point on that. Therefore, on Monday, the district session judge asked for a special medical board to be constituted.
okay.
And thereafter, he asked for a bone ossification test on our request because the family member had, he had asked the family member to appear before him. She appeared with her birth certificate showing the same parentage as the accused. So that date is on 24th. The report of the special medical board is on 24th. And the district session judge has also directed, my lord, that in item 38, my lord, the accused is suffering from TB, which in a confined
No, we'll
jail.
go to 38 later on.
My lord, he'd given us sort of similar indication on both. So we are not aware of what date has been given in that, so we can hear that matter at the moment. From him, the mobile was seized, which my friend case diary shows.
No, in this case, what is your
In this
submission?
case, the seizure is not reflected, arrest memo is not reflected in the case diary. We asked the PI's court for certified copies. We asked the district sessions staff for the certified copies. No arrest memo, no warrant issued by any magistrate. They are not named in the main FIR 2 of 25.
Whether arrest memo is there or not? 47, 48 complied with.
The accused name is Akai, my lord. Akai Thake Cognac, alias Akoi Cognac. Any arrest memo in his case, my lord? Any warrant of issued by any magistrate? Any seizure list?
Rest memo is there, madam. 47 is there. 47 signature of Akka is there, madam.
47.
One Cognac. One Cognac. The phone number and signature is there.
We don't know who this Pawan Cognac is, my lord.
One Cognac.
In fact, if I may finish, the submission was that before the district session judge on Friday last, Akoi Cognac could not even answer the district session judge. He only speaks Nagamese and Cognac. The district session judge is the kindest man to ask him. And I was wondering how the IO could ask him all these details. Even the address is shown as Myanmar.
No, what is your submission now?
My submission is, my lord, the IO has written his case diary. My friend is referring to it. But the district and session judge found that
What was the date of your arrest?
7th of August, 2025. And it was because I was simply a roommate of the other accused, my lord. We were both given accommodation by the Naga Kitchen administration.
Where is the arrest, the forwarding report?
We don't have anything. We could not find anything on the record. That's why I'm asking my friend to.
When he was arrested,
Nothing was
forwarding
handed to us also. No next friend was
7-8
informed.
along with two persons were.
My friend would also inform us whether the arrest memo or anything was given to the Naga Kitchen administration. Because we found nothing on record, we got no copy either. My friend found his record.
No, Mr. Chaudhary,
But
you have to first make your submission.
I'm trying, my lord. Sequentially, one goes. The crime branch case 2 of 25 dated 29th of April 25.
No, we have
We are
directed,
not, we are not named in that. Thereafter, my friend finds
no,
him,
but we have directed the ascertainment of his age.
my
So
lord,
we
one is
have to,
that.
we have to wait
One is
for,
that. We have to wait for that.
for the.
We have to wait for that, but that's not a bar, even if I submit for the bail at the moment, my lord.
Yes,
Because
yes,
one
yes.
day extra in jail is not
Yes,
worth
there
it.
is no bar.
One day extra.
So
in
what
jail
is your submission? You are not
submission is
making
that
your
He
submission.
has to be immediately released, my lord, on bail.
On-
He'll assist the IO.
On what ground?
On the ground, my lord, that he has been arrested wrongfully. There is no memo of arrest to show what his involvement is in the various sections of the BNSS or with the UAPA.
Yes, Mr.
The very ingredients of the sections are not found against this
Okay,
court.
okay. Okay. Heard Mr. P.N. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. By order dated 9/9/2025, this court had directed the Court of Learned Chief Judicial Magistrate to conduct an inquiry as regards
District and
to ascertain the age of the present petitioner. However, it appears that no report has been received with regard to this said order.
Lord, it was district and session court. Lordship said CGM.
Stop. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offense alleged in this case. He also submits that at the time of his arrest, he was not served with the notice under section 47 of BNSS, and no grounds of arrest were stated to him. He further submits that the petitioner understands only which language?
Cognac,
and
Nagamese to
And
some
Nag-
extent, my lord. Nagamese
and-
is basically in the Dimapur
Nagamese.
area. Eastern Nagaland doesn't have Nagamese.
He further submits that the petitioner was produced before learned special judge on
Friday was 15th. No, Friday was 12th, my lord. 12th of
12/9/2024. And due to the language barrier, he was unable to communicate with the court.
I stand corrected, my lord. It was on 11th September.
11 September.
12th was a holiday.
On the other hand, learned additional public prosecutor, what is the acquisition?
He and that other person, they were on the same place. They have link with NSCN, Agami group, Malak. And as per the instruction, Malak, of one of the Christian Kedar Malak, they have come to Guwahati, and they were brought by that person, Malak, already in the bed. And they were waited for the further inspection. They have come prior to 2 months prior to August. And what they have.
Okay. Learned additional public prosecutor submits that there are materials on record to suggest that the petitioner has linked with the members of NECN,
Angami, he said.
members of proscribed organization NECN.
Angami. Below there are 5 NSCNs. My friend should clarify.
NSCN Angami.
NECN within bracket Angami.
They restricted to the Angami tribe.
But the acquisition was
Now, fusion with now also, Malak. They have other persons also, Malak.
Okay,
Casting
you give me
stones
the
in the dark.
case. I have considered the submissions. I'll pass the orders in chambers
My lord,
after
and
going through the.
one I would, my lordship knows far better than I do. From the Alpha, my lord, there are few members who are from the Muslim community, they retain their names. All others have never taken a Christian name, my lord, including the leader and others. My friend as a prosecutor should know that also, my lord. The name.
Okay, I'll go through the case diary
That's
and
why I'm
pass.
saying the IO has not even gone to the area where this mobile was bought. He is not ascertained where these people are coming from. He is simply naming a village. They are not even from the same village. There is a distance between the two villages.
Okay.
They met in Dimapur. He has not even ascertained that.
I'll go through the case
My
diary.
lord. And apart from the case diary, our submissions may also be regarded.
And Longsang,
Next case, my lord, what happened is that he was the one contacted by my friend's client for a job in Dimapur. The Dimapur, where he was brought here, and Akai came with him. Being from the same tribe, Dimapur being from the mixed tribal area, these two were from a very minor group, my lord, of Naga tribals under the schedule. They came to the Dimapur, from Dimapur to Guwahati because there is no opportunity and employment in Dimapur anymore after the bringing in of the inner line permit. They came here, but they are not from the same village. They met in Dimapur. My friend has to also clarify that, because if his client had met them from the villages and they were childhood friends, they need not have come here together, my lord. So what happened in Akai's, in the case of Longcha is, he had been already undergoing a kidney and a liver ailment. He needed money for his medical treatment. He was the one who was the one in the need of a job. He also required care and attention. Now it has come to light, my lord, that he is also suffering from TB. Now, whether the jail doctor, my lordship had asked the jail doctor to examine him, I had requested that he be examined by the super specialist in the GMC. And to some extent, my lord, the special judge also ordered that he be examined properly. Because these are infectious diseases, it could make the entire jail come down, my lord. And with the liver and kidney disease, it's I mean, under the national health policy, my lord, it's a very vital treatment to be given at the cost of the government. For Longsha to get this kind of treatment by the government of Nagaland, he has to be registered there. Now he is here in the central jail. Now my friend will have to register him and give him the treatment. And later on, after the technical examination, forensics is done on his mobile. That may take 6 months, it may take a year. My friend has already submitted that the IMEI number of the mobile is linked to the SIM card bought by Longcha. Longcha bought a SIM card in the name of somebody else. So my friend has linked the mobile to the SIM card, Geo SIM card, which number I've given in my petition. He has not informed us whether that Geo SIM card has made numbers, any phone calls to anybody who's from any band outfit or anybody, or was it only to family members?
Okay. What is your sum?
My lord, first submission is that Akitheke Konak and this Longcha Konak, both are from Mon districts, district same. And my lord may see page number 2. In Longcha Konak, his PIN number is 79862.
It will remain the same.
And Akoy Konak is 79861. So nearest village, my lord. Both the persons are nearest village. Now Longcha Konak, my lord, he used the mobile phone, which mobile phone earlier used by James Sasam, because the IMEI number, my lord, are same. One handset have one IMEI number, maybe SIM card, maybe change. Now the James Sasam, which used the mobile, same IMEI number has been used by the Longcha Konak. And these Longcha Konak, they are the of same district, Mon district, maybe the villages are different, but my lord may see the PIN number 79861 and 79862 nearby village, my lord. They both came to Assam, my lord, and my lord, their statements I have, my lord, flag mark, their arrest memo 47, 48, all are flag mark, my lord may see. Specifically, it is mentioned that the same IMEI number which was used by James Assam has been
Okay,
now
okay,
used by
okay, that submission you have made.
That's what
My lordship would add to his
they
submission
have
that
come-
it's a second-hand, it's a second-hand mobiles. Second-hand mobiles, my lord. They stated that.
They have linked with NSCN Angami group, my lord, and with the instruction of a one person, that is name is dear, my lord. With the instruction of that person, they have come to my lord, Guwahati, and they are waited for the further instruction.
Lordship would know, my lord.
Okay,
Lordship would know
no,
that
no,
in
no,
Nagaland,
no more,
the
no more,
Nagaland
no
and
more
tribes are separate.
submissions.
So then they're not mixed up.
There
He's
cannot
trying
be
to
a
suggest.
continuation of one after another.
He's trying to mix up the tribes, my lord. That's very nice of him. That's very much part of the country, but they don't mix up.
Learned counsel for the petitioner has submitted that that the present petitioner is suffering from ailment, kidney and liver ailment, and he has also been diagnosed with TB. He further submits that he hails from Dimapur, you are saying.
You know, originally from Eastern Nagaland, but he, when he came with his client, they were in Dimapur.
He was brought to Guwahati by one of the co-accused, namely Poang Konyak, along with Akire Akitake Konyak. He further submits that the petitioner is also innocent, having and in no way connected with the offense alleged in the FIR. On the other hand, learned additional public prosecutor submits that there are materials in the case diary which indicate his complicity in the offense alleged in the FIR. He submits that the mobile handset seized from the present petitioner was earlier used by James Assam, which is verified by the IMEI numbers of the said mobile. What is the date of your arrest?
7th of August 2025. They're showing it at 1 o'clock at AIDC, whereas it was in Naga Kitchen I was arrested.
Okay.
Which is not AIDC.
He further submits that the petitioner hails from Mon district and he was brought to Guwahati by the co-accused Poang Konyak on the instruction of NSCN Konyak, and he is waiting, and there are materials to indicate that he was waiting for further instructions from the proscribed NSCN Konyak group. NSCN Angami group. I have considered the submissions made by learned counsel for both sides and have perused the case study. I'll pass orders in chambers after perusal of the case.
Deeply obliged.
You flag that.
Deeply obliged. My friend, I think, still has. Like, I think 24.
Yes.
In this case, the petitioners, my lord, they are aggrieved by the, my lord, rejection of the petition for grant of Jimma to the mobile phones which was seized by the IO. These were the original petitioners whom bail was granted earlier, my lord. Their mobile phones. Now from, my lord, since the date of their arrest, it is about
Is 140.
You get a report.
Malat, yes, Malat, I have talked with the IO, Malat, because motion it has come, Malat, and there is nothing to in the city, Malat. Huge in the Polina city because of, I have talked with the IO. Malat, he said that the mobile handset is a vital, Malat, one evidence, Malat, because Malat, they have connection, they have whom they have call and all this in the mobile phone, Malat, and so till now, Malat, in this particular case, 18% has been arrested, Malat. Few got bail, Malat. That is another thing, Malat. Charge sheet not yet submitted. So at this stage, Malat, it is difficult to.
No, that is why I said, my lord, I have submitted before this court, my lord, that it is the data which they want. Let them collect the data. Till date, they have not sent the phone to the FSL for collecting the data. Let them take the data. Let them keep the data. Hand me the phone. Because tomorrow, if they do not take the data and the phone is kept like that, and it becomes bad, it becomes of use to nobody, my lord.
My lord, some time may be given, my lord.
Because that is the procedure that is which is to be followed, my lord, after Sundarlal and my lord. Even, my lord, because the phones were not even produced before the court, my lord. Then, my lord, this
Though the case diary is there, you may take instructions.
So if the case diary also does not suggest that they have even produced it before the court, my lord. So what stopped them? Why? What stopped them from giving those mobiles if the data is of so much concern to them, my lord, that they would have, my lord, sent it to the FSL because the IO cannot collect the data, my lord. It has to be collected by the FSL, and he has never even produced it before the FSL.
Let one by one.
Several persons have been arrested.
Any other submission? If there is no other submission, I will dispose it off to you.
That is the submission, my lord. That is the submission that, my lord, did the data they want, not the phones. So let them collect the data and hand the phones to me, my lord. That is my submission, my lord.
Okay.
And that is the vital evidence, my lord, as per the telephonic discussion with the IO, my lord, because the city is here, my lord, and several persons were arrested, and my lord, huge diary, my lord, investigation is going on, my lord.
Because the battery, the mother phone, the keyboards, all these things are of no help to him, my lord. The data is of help. Let him keep the data and give the phone back to me, my lord.
But it can be given or not,
You
my lord,
take instruction.
a report may be.
Heard Mr. G. Chaudhary, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. You have sought for Jimma of the vehicle?
Of the mobile.
Of the mobile from the, it was rejected, no?
Yes, my lord.
The
Rejection order, why I have come before your lordship, my lord, the rejection order does not reflect as to how, my lord, Sundarlal was, my lord, applied, how, my lord, this Rajesh Maurya was applied. All those things are not there. Just he said that the IO has said
this
that
application under section 528 of BNSS has been filed by the petitioners, namely Nemka Konyak / Yaman Konyak and S. Hengmei Konyak, impugning the order dated 19/7/2025 passed in Miss Case number 149/2025 arising out of Crime Branch PS Case number 2/2025, whereby the prayer for Jimma of the mobile handsets of the petitioners, which were seized in connection with the aforesaid case, was rejected. The learned additional public prosecutor submits that though the case diary is available, though the available case diary is available, however, since it is too bulky, he may be granted some time to get necessary instructions from the
Report, my lord.
instructions / oblique report from the investigating officer. The prayer is allowed. The investigating officer is directed to submit a report regarding as to whether the requirement of retention of seized mobile is still there for the purpose of investigation. And as to why the custody of same may not be granted to the present petitioners. Let this matter be listed again on
25. After vacation.
after vacation,
15/6.
22nd October.
May I please your lordship? Lordship, anticipatory bail application, my lord, allegation under section 140 subsection 3 and 3 subsection 5 of DNS, my lord. Petitioner is on interim, my lord. Lordship will find the FIR, my lord, at page 10, my lord.
You cope appear
My lord, in this case, my lord, I am sitting, my lord, the girl age is, my lord, 17 years, 9 months, 23 days at the time of the offense, my lord. The allegation is that petitioner, my lord, taken away that forcefully taken away the girl. Subsequently, she was recovered. Father is the informant here, my lord. His father statement is there. Complainant, he stated that after her recovery, when she attained the age of 18 years, she was married to some other persons, my lord. And now they are not wanting to, my lord, pursue this case, my lord.
Mr.
S.A. B. Khabir.
S.A.
B. Khabir, my lord.
S.A.B. Khabir, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner was granted interim bail by this court on 6/5/2025, and he has, in pursuant to the directions of this court, he has cooperated in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Mokalmua PS case number 339/2024 and has submitted that the petitioner has cooperated in the investigation and his custodial interrogation is no longer required. Stop. Considering the submissions made by learned counsel for both sides, the interim bail granted to the petitioner on 16/5/2025 is hereby made absolute, with condition number 1 and 2 attached to the said order remaining intact. This send back the case diary. This bail application is accordingly disposed of.
39 is, my lord, 40, my lord. Interim order is earlier, my lord. There is one petitioner.
Yes, it does.
In-
42. Oh, okay.
I did 40, my lord.
Interim order dated
Here 65, but here not 65.
Interim order that is, my lord, 17/12/2024.
17/12.
same order. Instead of petitioner, petitioners, plural. Interim order dated
12/2024, my lord.
17/2024. Same order.
Applies, my lord. I did 42.
Thus, in this matter, by Lordship's last order, the petitioner was already granted anticipatory bail. However, if Lordship would kindly have the last order of 28th of August, at page 2, paragraph 8, we had filed an additional affidavit, which consisted of a letter which was sent to the senior SP of Dibrugarh, wherein the petitioner had complained about the conduct of the IO in the case, and Lordship had called for the report of the senior SP regarding this complaint. So
That report prepared by additional SP and so senior SP, my lord, doesn't forward it to me, my lord. And they have conducted them, taken the statements of the, my lord, all the, my lord, accused person in the case, my lord. Now regarding the concern, Anita Das, my lord, she in the second page, my lord, she stated that, my lord, at that time I was in stress and scared, and as it was my first time in the police station, so I mentioned those words of threatening given by the IO. Currently, I do not remember what exact conversation took place between me and the IO. Subsequent, that is the
The interim bill was made absolute.
interim was the-
It is only for this.
only for this.
Only for the report.
That report must be kept as a part of the record.
Okay, I'll go through the report and pass the orders. Necessary orders. And dispose of this case. Let me go through the report.
Please.
In the chamber, I will pass orders.
This dispose of.
Dispose of.
Grateful.
May I please?
Yes.
Lordship, in this case, the FIR is at page 11, annexure 1. I'm reading the vernacular one. এজাহাৰকাৰী বিনীত নিবেদন এই যে 2 নং আসামী মোৰ পত্নী হয় মোৰ নিম্নলিখিত নাবালিকা কন্যাক এইবাৰ বৰবৰী জাতীয় বিদ্যালয়ৰ 10ম শ্ৰেণীত পঢ়ি আছিল।
This is item number.
43.
Heard Mr. S. N. Tamuli, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor, as well as Mr. A. Alam, learned counsel for respondent number 2. In this case, by the order dated 9/5/2025, Ms. Pooja Agarwal was appointed as amicus curiae to represent the cause of respondent number 2 in this case. However, since the respondent number 2 has engaged a private counsel, she is released from this case. The private learned counsel for the respondent number 2 has prayed for some time for filing a written objection against the prayer for anticipatory bail filed by the petitioners. Prayer is allowed. Let this matter be listed when?
The next week, Lordship, because the petition is coming.
Atul. 26.
CD to be written.
CD 26 September. CD may be retained till next week.
44.
The Lordship will see in this case how law is being misused, my lord. The subject is of the school 59 years, my lord. He has gone to a pharmacy, my lord, just saying, my lord, so that your Lordship will get. He has gone to pharmacy for checkup of blood pressure, etc. In that pharmacy, many people are sitting. One of my students, 2 students also came. Then, my lord, the examination was ahead of that period, my lord. So they wanted a blessing. I touched her head, my lord. All that God may bless you. They came out and she filed a case to the principal. First, she filed a case before the principal, my lord, saying that he tried to outrage a modesty. Then principal called for a bichar. Before the bichar was held, my lord, they started demanding 6 lakhs of rupees. And this person is to be transferred from the school. Oh, this is the background of the case, my lord. Now you will kindly see the FIR. You will see kindly how the law, page 11, my lord, you lost them. Or vernacular, you will find page 15, my lord. That is clear. Vernacular will be better, my lord. Page 15. এই যে যোৱা 20/8 তারিখ 5:30 PM. You will kindly note this time, my lord. Very busy schedule. মোৰ ছোৱালী ফাতিমা আৰবিন ৰংগীয়া ষ্টেট বেংকৰ সন্মুখৰ ফাৰ্মাচীৰ ঔষধ আনিবলৈ যাওঁতে ফাৰ্মাচীৰ ভিতৰত পদকীয়াক লগ পায়।
পদকীয়ায় হত উদ্দেশ্যে certain number she will be under influence of that. The pharmacist examiner not minor. Person who are there, whether anyone minor.
Lordship, and
At the case set,
At this stage, but at this stage.
at this step.
Always.
45.
Yes,
This is second bail application lordship. FIR lordship will find at page 9. Two petitioners,
second bail.
two petitioners before your lordship, others were granted bail lordship.
FIR is at page.
9. Starts from page 9.
What is the accusation?
Accusation is that initially lordship, there was dispute between two ladies. Subsequently, family members of both parties got involved, and in the said incident, lordship, one person died. One person got injury, lordship, he subsequently died. So the FIR was initially registered under section 109, and subsequently, lordship, 103 was added. He did not die on the spot.
What is your name?
My name is lordship Saddam Soiful Hussain and Saddam Hussain.
Accused number 1 and
Yes,
2.
1 and 2. And last order, lordship will find that page starts from page 18. Now, lordship may kindly see paragraph 10 and 11. Okay. 11, 12, 10, 11, and 13, lordship may kindly see.
Yes. Please read.
As regards to other accused persons, he submits that they are also involved in assaulting the other victims. However, he submits that the medical report of the other victims, as well as the statement of injured Imtaz Ali, is not there on record. He therefore prays for allowing the prosecution side to produce an updated case diary. I have considered the submission made by the learned counsel for both sides. The paragraph 13 also, it also appears that the alleged incident occurred on 26 February 2005, and even after lapse of almost 3 months, the statement of the victim has not been recorded. So I am on that note. Whether I am coming now, this order was passed on 15/5/2025. So whether those medical reports of the victims are there or not, and
Who is the victim?
victim is Imtaz Ali.
Imtaz Ali died.
Right.
Now, who else are the victim?
Arshad Ali, sorry, I am not sure. Imtaz Ali is injured. Arshad Ali, lordship, subsequently died. Page 10, your lordship get Arshad Ali and Imtaz Ali sustained injuries in the incident. And after, while undergoing treatment, that Arshad Ali died. That's it.
Now, what is your submission?
My submission is that injury reports were not there while earlier bail application was considered.
Okay,
And the
that is the
statement
change
of
circumstance.
and victim's statement is also not there, which might help.
Victim means Ashad.
Imtaz.
Imtaz.
Imtaz Ali.
Imtaz statement is there.
Is the informant.
Victim.
Victim is Ashad Ali.
And one, how many persons were injured?
One died.
Second one is?
So, lordship, injured statement of 4 person is there, lordship, available here, lordship. And in PM report is also here, lordship, describing that the cause homicidal in nature caused by sharp pointed weapon, which are caused by blunt weapon, and lordship then perils, lordship. Lordship, the pictures, lordship.
No, okay, I have seen it.
And lordship, sufficient incriminating materials, lordship. This is not a fit case, this is a bail application, lordship. Statement of victim, statement of witness, lordship.
Yes, yes.
Here, my submission is that the injury medical reports of other victims. So apart from postmortem report, that whether those other injury reports of the victims are there or not, because they have implicated me.
Yes,
And
it
if
is
they are,
there,
that is what I am submitting, Lordship, whether their injury reports are there or not. And Lordship, that victim Imtiaz Ali, he was with Lordship that deceased Asad Ali when sustaining the injury. So whether his statement is there or not, that
No,
is my
sir.
other submission.
Is,
Because the order,
is this your submission that you have not assaulted the deceased?
there is no specific, because there was a group fight, Lordship. Who assaulted whom, that was not clear, Lordship, in the incident.
statement of witness, lordship, their lordship, witnesses implicated, lordship, clearly implicated these two petitioner, lordship. The statement of witnesses are there, statement of injured are there, lordship. Medical reports are there, lordship, and this is not a fit case for anticipatory bail application, lordship.
Yes, Mr. Sen.
All respect, my lord, I am the brother, elder brother of the person, my lord, who killed by these two assailant, my lord, these petitioners. My lord, what has happened? There was a
What is the name of the informant?
informant Nausad Ali, my lord. Nausad Ali, I am the informant, my lord. My brother, younger brother, has been killed by this, my lord, petitioners by a sharp weapon, my lord. Repeatedly, he has been
Just a minute.
assaulted.
Petitioner's names are?
Saiful
and Saddam.
Saddam. These are the, my lord, persons who criminally trespassed into the house of the informant, my lord, and repeatedly assaulted with a dagger, my lord, sword, and my lord, seriously injured. There are altogether, my lord, 5 persons injured, and serious
Of accusation is court paragraph number 3 from page 19 of the bail application. Learned counsel for the petitioner has submitted that this is for the second time the petitioner has approached this court seeking bail. So, on an earlier occasion, the prayer for bail was rejected. Prayer for anticipatory bail was rejected by this court by order dated 15/5/2025, passed in AB case number 998/2025. Learned counsel for the petitioner has submitted that while rejecting the anticipatory bail application on earlier occasion, the medical report of the injured victims were not there in the case diary, whereas further the statement of victim were also not recorded at that point of time. He submits that by now sufficient period have been lapsed and the statement of the victims might have been recorded, and therefore he has filed the second bail application. On the other hand, learned additional public prosecutor has produced the case diary of Goremari PS case number 23/2025 and has submitted that there are sufficient incriminating materials against both the petitioners. She submits that the statement of the victim are also recorded and they have implicated the petitioner in the offense alleged in the FIR. She further submits that the photographs of the injuries caused sustained by the victims are also there in the case diary, which would reveal the nature of which will reveal the seriousness of the allegations made against the present petitioner. She therefore prays for rejecting the anticipatory bail application. On the other hand, Mr. B.K. Sen, learned counsel for the informant, has also submitted similar to that of learned additional public prosecutor and has vehemently opposed the grant of anticipatory bail to the present petitioner. He submits that the brother of the informant had succumbed to the injuries sustained by him, and the uncle of the informant also sustained serious injuries on his person. He submits that this is not a case of false implication, as medical reports from our photographs and postmortem report reveals the truth. He therefore prays for dismissing the anticipatory bail application. I have considered the submissions made by learned counsel for both sides and have gone through the case diary of Goroi Mari PS case number 23/2024. On the earlier occasion, the prayer for bail of the petitioner was rejected on the ground that there were sufficient incriminating materials against both the accused persons. In the meanwhile, some more witnesses have been examined and the situation remains same. There are sufficient incriminating materials against the petitioner in the case diary, which do not justify allowing them to go on anticipatory bail at this stage. Accordingly, the prayer for anticipatory bail is hereby rejected. Send back the case.
Problem. Nice, Nuclear.
46.
FIR page 12, my lord. That was the case, my lord, one my lord Biswajit, my lord Roy, my lord, who was the secretary of the Post Residency Students Union. Incident was of the year 2007, my lord, and charge sheet was filed, my lord, in the year 2023. Thereafter, case is proceeded. It is charge sheet also accepted, my lord, but he has not direct involvement, and he has also took steps before the learned trial court, my lord, judicial magistrate first class degree.
Why your prayer was rejected by the trial court?
But I mean, he is apprehending that in the event of appearing before the learned trial court.
This is anticipated.
302 is there, my lord.
Is there any material against him?
Yes. Materials are there, Lordship. It was under his leadership, Lordship, the riot took place. There are a number of persons who were injured through burn injury, and one person died. One vehicle was destroyed. So all that is there, Lordship.
That is already there in the FIR, my lord. He
in the charge sheet also.
Charge sheet there, but direct involvement, no, not. He was the secretary. There were, my lord, 20, more than 50, 35, 36 persons were there, my lord. Out of them, as he was the secretary, his name is reflected at the top, my lord.
Have you received summons?
Yes, my lord, I have appeared there. I have taken steps there. Last page, my lord, kindly see your lordship. Taking time there, my lord, and next date is fixed on 1/12/25. My prayer is that, my lord, I will appear, my lord, co-part of the investigation, my lord.
Because after
Not
6
investigation, trial, trial.
The trial, my lord. I appear there, my lord, but my apprehension is that, my lord, for defense, my lord, simply it is not required, my lord, custodial, my lord, detention, because when the judicial magistrate first class, my lord, it is there, my lord. Thereafter, for committing the offense, it will be.
Your name has been shown as an absconder
No, my lord, I am appearing, my lord. From the very first day I appear, take two
in the
steps.
charge sheet, where he was on bail
No,
earlier,
his statement is there in during the investigation.
but he was not arrested during investigation.
That I am not.
Not arrested. He just, my lord, after receiving this
Because
summons,
Lordship, the 302 was added on a letter.
later.
Okay, but he cooperated in the investigation.
Yes.
Now why to detain him?
Lordship, it will be wrong to presume, Lordship, that he will be detained, Lordship. It is only fixed for appearance, Lordship.
No, but the court is a committal court
Yes.
and there is embargo under section 480.
Yes. Then Lordship will have to go by the materials that is present in the charge sheet, Lordship. We will have to go by that, Lordship.
Okay,
Because it is best left to the wisdom of the concerned court, Lordship.
no, even if court intends to grant bail, it cannot. Magistrate court.
Then Lordship will have to peruse the materials that has been collected from the charge sheet, Lordship.
No, assuming that there are materials are there.
Lordship.
Now, is there any apprehension that now he can abuse his liberty? Because he was not even arrested during investigation.
And from the very first day onwards, I am appearing. They are taking steps. But apprehension is that, you come and it will be arrested.
Heard Mr. H. Das, learned counsel for the petitioner. Also heard this Mr. B. Sharma, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Shri Bishwajit Ray, who is apprehending his arrest in connection with PRC case number 1713/2023, corresponding to Golokganj PS case number 579/2007 under section 147/148 149/436/326/326/307 of the Indian Penal Code /302 of the Indian Penal Code, read with section 4 of the Prevention of Damage to Public Properties Act. Learned counsel for the petitioner has submitted that in the aforesaid case, where is the charge sheet?
Page, that is page 40. Type 40.
Page?
Page 40.
No, original charge sheet.
Original charge sheet, is starts from 41.
Where is your name?
My name is page 41. The brief of the CS of the case is that on the basis of the FIR lodged by the complainant SI Kamal Chandra Seal.
No, that is typed copy. Where is in the original FIR? Have you? What is the status?
Page
shown?
20, Lordship,
Page
20. A1, he is A1, Vishwajit Ray.
whether he was shown in custody or on bail.
No, Lordship, that I have seen, Lordship, it is not shown, Lordship.
What was the status?
Status, judicial magistrate first received this CR.
No,
Page 20, last, down below, Lordship, you find A1.
none was arrested. No one was arrested.
No, somewhere arrested, Lordship. No date, nothing.
Date of arrest is no there.
Nothing is there.
Because it has to be mentioned,
Yes,
status of accused,
yes. It is still mentioned
column number 22,
whether arrested or
whether arrested or
on
not
bail.
arrested,
Yes.
whether on bail, nothing has been mentioned in the. Yeah, ये लिख ले. Huh? Last line. No, no, last line, last line. Okay. Submitted that the petitioner was not arrested during the, your statement were recorded, not arrested during the course of investigation. However, he cooperated in the investigation and his statement were recorded by the police under section 161 of B CRPC. He further submits that though the FIR was in this case was lodged in the year 2007, in the year 2007, however, charge sheet was laid in the year
2023.
2023. 23. He further submits that after receipt of summons from the court of London, which court?
Judicial Magistrate First Class Dhubri.
Judicial Magistrate First Class Dhubri, the petitioner has appeared through his engaged counsel and has sought for adjournment.
Yes.
However, as the court in which the PRC case number, what is the PRC case number?
Well,
PRC case number 1713 is pending in the court of Judicial Magistrate First Class. Hence, he apprehends that due to the embargo in section 480 of BNSS, the said court may not grant bail to him even if he appears personally before the said court. And therefore, he plays for allowing the petitioner to go on into anticipatory bail. On the other hand, London Additional Public Prosecutor has submitted that there are sufficient materials against the petitioner in the charge sheet, as he was the leader on whose instructions the writing took place, which led to death of the victim. Stop. I have considered the submissions made by learned counsel for both sides. On perusal of the records, very strangely it appears, it is very strange to note that in the charge sheet under column number 22, against the particulars of the arrested, particulars of the accused against whom charge sheet has been laid, the status of the status of accused as regards his arrest or bail has been kept blank. Stop. It also appears that the statement of petitioner were recorded by the investigating officer during the course of investigation, which indicates that he had cooperated in the investigation. So, as the court in which the PRC case number 1713/2022 is presently pending is a court of judicial magistrate first class. It may not be able to grant bail to the petitioner even after his appearance before the said court, in view of the embargo contained in section 480 within bracket 1 within bracket small Roman 1 of DNSS as offense under section 302 of Indian Penal Code is involved in this case. Under such circumstances, if the petitioner cooperates in the trial, this court is of considered opinion that he may be granted bail in this case. Accordingly, this anticipatory bail application is disposed of with a direction to the petitioner to appear before the Court of London, Judicial Magistrate First Class, Dhubri, in PRC case number 1713/2023. When is the next date fixed?
165.
On 1/12/2025, and cooperate in the investigation. If he does so, on the said date, the committal court, that is the said court, shall allow him to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the said court with following condition. Number 1 and number 2, trial condition.
The statement was recorded on 29/10/2007.
Yes. উপরত লিখিব। The statement of the petitioner was recorded under section 161 CRPC on 29/2/2007. 29/10/2007.
Item 47. Charge sheet has been submitted.
You are on interim. Heard Miss S. Nazneen, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that though the case diary was called for, in the meanwhile, charge sheet has been laid, bearing charge sheet number.
Oh, charge sheet number, I'm sorry. Charge sheet number 374/25, dated 7/9/25.
Stop. Learned counsel for the petitioner submits that the petitioner was allowed to go on petitioners were allowed to go on interim bail by order dated 9/9/2025, and in pursuant to the directions of this court, they have appeared before the investigating officer and have cooperated in the investigation. So, considering the submissions made by learned counsel for the petitioner, the interim bail granted to the petitioners by order dated 9/9/2025 by this court is hereby made absolute, subject to the condition that they shall continue to cooperate in the trial. Stop. This bail application is recorded.
Ordered. That would be.
My lord, conviction under 138. Thereafter, my lord, along with the compensations, 6 months imprisonment, and my lord, 2 lakhs of rupees with compensation. I have paid the amount. Both of us have filed an affidavit. The case is there, my lord, number 1020. Both of them has filed an affidavit and my lord, a miscase. They have stated in paragraph, my lord, 8. And my lord, the conviction was at page 24, your lordship will find in the appeal memo. Revision, sorry.
Heard in IA. In IA, what you have done?
My lord, here they have taken the money and both, there are two affidavits at page 8 and 9. The person, the petitioner along with the complainant, both of them have filed an affidavit, and in para 8, they have said that after full and final payment received by respondent number 1, applicant number 2.
Heard Mr. P.K. Roy Chaudhary, learned counsel for the applicant in IA. Huh? Also heard Mr.
A. Malik.
A. Malik, learned counsel for the
Respondent number 1.
the respondent number 1. This interlocutory application has been jointly filed by the, has been filed by the applicant slash appellant slash revisionist of criminal revision number 446/2018, whereby it is stated that the
Amount, page 24, your lordship, in the revision petition, page 24.
No, in the IA you have mentioned how much you have paid.
My lord, in para 7, I have stated, my lord.
That the petitioner, that the applicant has already paid the
total 2 lakhs of rupees.
Total amount of rupees 2 lakhs to the respondent, and respondent has accordingly compromised the matter and accordingly has prayed for disposing of this matter on the disposing of the connected criminal revision petition on the basis of compromise by setting aside the impugned judgment of conviction and sentence imposed on the petitioner. The interlocutory application has been supported by affidavit. Where is the affidavit of
page 8 and 9? Both the affidavits are there.
Affidavit of the petitioner as well as that of the respondent. Learned counsel for the respondent, namely Abidul Rahman Laskar, has also submitted that the matter has been amicably settled on compromise and this matter will be disposed of on compromise. Stop. Considering the submissions made by learned counsel for the petitioners as well as averment made in this interlocutory application supported by the affidavit filed by both the parties, the prayer is allowed. The criminal revision petition number 446/2018 is disposed of on compromise, and the impugned judgment and order dated 12/9/2018 passed by learned Session Judge Hailakandi in criminal appeal number 6/2018, as well as that of, where is the original?
Original at page 24, you'll also will find the operative portion. It starts at page, my lord, 11. 11, 12.
No, original case number, NI case number.
Original case criminal, original case number, my lord, is CR case number 28A of 2013.
And the date of judgment?
Date of judgment, my lord, date of judgment is. Date of judgment, page 24, my lord, it is. It is, my lord, 22/12/2017. Page 18.
22/12/2017.
17.
And the court which passed, which court?
Additional Chief Judicial Magistrate Hailakandi. CR case 28A of
What was the
2013.
last line? As well as judgment dated 22/12/2017, passed by the Court of Learned, Additional Chief Judicial Magistrate Hailakandi in CR case number 28A of 2013 is hereby set aside. This interlocutory application is accordingly disposed of. In main criminal case, heard Mr. P.K. Roy Chaudhary, learned counsel for the petitioner. Also heard Mr. A. Malik, learned counsel for respondent number 1. In view of the orders passed in IA criminal number 1020/2025, today, that is on 18th of September 2025, whereby the compromise arrived at between the parties have been recorded. This criminal petition is criminal revision petition is accordingly disposed of, and the impugn orders are accordingly set aside. Send a copy of this order to the trial court.
Item 49. May it please the lordship. My lord, there is a criminal appeal IA is there, my lord, about 982 for bail. My lord, suspension of the sentence. My lord, conviction under 7 and 8 of the POCSO Act for 4 years. I was arrested on, my lord, 11/9/2024. My lord, if I take into account also 471 and 436A, my lord. 471 says, my lord, first time offender 1/3. Now it is 16 months in 48 months, 16 months, already 12 months is over. And my lord, if I go by the statement of victim of PW1 and PW4, the informant, PW1 says that he only touched me. That means page 14, para 14 of the judgment, PW1 statement, 11/9/2024, my lord. More than 12 months is over in a total of 48 months. And my lord, my age is around 64. So my age 26 years. I'm a young boy of 26 years, my lord. If your lordship may look into the statement of PW1 in the judgment.
Yes, Mr. Sharma.
12 months is over.
So this is a small matter, hearing can be done on a short one. Very small matter.
My lord, let me start the argument. My lord, only by saying, my lord, it's saying that it is a small matter, evidence has to be looked into. My lord, this case has been coming before the honorable court for last 8 months, 8 times.
2020.
And 12 months. In
Oh,
40
okay.
months, 12 months is over.
Okay. Yes,
sir.
Mr. Das.
Not that, Malad, the case has no merit, Malad.
Whose case?
Malad, the
Prosecution's
Yes.
case.
The
Case is merit, Malad, because one of the young girl coming out of a tuition center, Malad, was allegedly molested by the appellant.
by the statement says,
No, Malad, if your lordship will go to the defense evidence, Malad, they could not make out any kind of motive, Malad, rather it appears from the DW that Malad, something had happened at the place of occurrence, Malad. So Malad, there are merits, Malad. So Malad, since the records are there, lordship can hear it, Malad. Yes.
Malad, your lordship may just look into para 14. This is a verbal statement. I'm placing what the trial court has said.
No, what is your response to the submission that the matter can be heard finally?
But heard finally, my lord, then by that time, my lord, I can take it for my lord. Then your lordship may give observation that within 1 month, if hearing is not concluded, he will be released on bail. I am taking that, my lord. My
No,
lord,
we'll
this is way by placing the person behind the bar after 3 years. Or, my lord, there can be a way. They have to indemnify that if ultimately there is an acquittal, they will immediately pay the compensation for me. Well, nowadays, your lordship will understand for every POXO case, there is, because the law lays down, they have to be compensated. But I am 12 months behind the bar. In 48 months. Total is 48 months. Why not for last 12 months, there is a trial, there is a hearing of the appeal, my lord. For 12 months, if the appeal could not be heard, how could it be heard within a month, my lord?
Victims.
My lord, even, my lord, in para 14, the victim statement, your lordship will find it, the court has described, my lord. And, my lord, the court held on the basis of.
Where is the victim statement?
My lord, in page 14, para 14.
Page
the
14.
Judgment, in the judgment.
Where is the judgment?
My lord, I have annexed in both, my lord, I also I have annexed, my lord.
You have annexed.
My lord, page 14, para 14.
Yes.
My lord, describing evidence PW1 deposed that on such and such, nearby such and such home and such, when she came out from the tuition of Subhendu Chakraborty's house, the accused on the road pulled her by holding her hand and she was alone. PW further stated that accused tried to drag her by nearby building, but she raised hue and cry and accused fled away.
So the dragging is.
Only dragging is there. Even not even said that she has touched the private parts or something like that. But
No.
holding a hand also does not mean that.
No, but still offense is there.
My lord, by that time, my lord, already 12 months I have been inside the jail, my lord.
Now, what is your defense against this?
My lord, this is what, my lord, sometimes the statements are said, your lordship will find. I have given my statement in the 330 section also.
No, I have to test whether is there any hope of you getting a favorable order.
My lord, that is, your lordship may look into the statement.
You just
my lord,
make one statement which would show that.
my lord, I am placing this, my lord, the evidence of your lordship, just vernacular, your lordship may look into that will clarify the whole issue.
No, what is your submission?
My submission, my lord, this incident, my lord, never could happen. These are all the personal grudges of between the parties, my lord. It doesn't happen anywhere, my lord. Only by placing somebody behind the bar nowadays, this domestic violence.
No. The evidence says there may be a submission that the sentence is of short period, but adding to that, there has to be
the evidence of the victim. This is I'm giving the original certified copy. Just your lordship will look into it. That itself will clarify.
Which portion?
Not I am marked, evidence.
No, which portion you want to rely?
This first portion.
She has stated what has been reflected in the judgment.
She has stated that. But my defense as regards this is this. I have not touched her in any way around. Because I am a young boy, they are trying for some other reasons behind it. They are doing all these things, what can I do? My statement is that I have never done anything of that. Your lordship may look into my statement also.
May I point just one paragraph 26 of the judgment.
And the court already held that because of preponderance of probability. Your Lordship, the trial court held.
Where?
Your Lordship may look into, but section 30 was never considered of the POCSO Act. Your Lordship will find in the judgment, my lord, the trial court has held, my lord.
Okay, heard Mr. P.K. Roy Chaudhary, learned counsel for the petitioner. Also heard.
But at para 11, the trial court held on the basis of preponderance of probability.
Okay, I am allowing the suspension of sentence and interim bail and bail during the pendency of the connected criminal appeal.
My lord. Public.
I'll pass orders in the chamber.
My lord.
So I have a small query in respect of item number 35, Lordship, this UAP matter, Lordship, which we had argued.
Yes.
Lordship, Lordship, I would like to make some submission regarding the maintainability of the bill application.
Maintainability of
The bill application itself, Lordship.
35, who is the petitioner?
Lordship, Ayu Chaudhary, I think. Lordship. That UAPA matter, Lordship, where he was convicted. UAPA matter, Lordship.
That is fixed for delivery of orders.
Lordship, I would like to make some submission, Lordship, because.
Okay, then I will again direct it to be listed.
Yes, Lordship.
You inform Mr. Chaudhary.
Yes, I will inform you.
Okay.
Lordship, I beg to, in respect of item number 51, Lordship, I have filed this, I have for delay, condemnation of delay, Lordship. And today is the 5th day, Lordship, the matter has not been, Lordship, reached, Lordship.
Yes, state. Do you have objection?
51 item.
Item number 51. 15 days delay.
355 days.
355. I'll go item number 51. I'll go through the records.
My lord,
If-
number 59, my lord, it is a and I body parties amicably settled matter. 59, my lord. Body party already settled matter. The petitioner has been behind the bar for the 145 days today, my lord. The petitioner has already paid the entire check amount. And amicably settled, my lord, already.
Who is for the other side?
Other side is also present, but it is probably with the court.
We'll
Matter
fix
will not
it,
be-
fix it on Tuesday.
My lord.
55 on Tuesday.
Monday.
Mr. Chaudhary, we are fixing it for further hearing on request of on 26. When?
Item 35 sometime.
After Puja vacation. After Puja vacation. Yes.
I would like to mention item number 30 for admission. 30, 30, my lord. This matter may kindly be listed on 6th November, my lord.
32.
630.
30. On request of learned counsel for the petitioners, let this matter be listed on 6th of November.
But
Tomorrow it will be item number 32 difficult. It is for only admission. No, we have, our board is full. If we, no, registry will give the date. I have requested the registrar, all leftover matters will be, dates will be given by registry.
Before.
It will not go after puja.
Lordship, I have a small submission. Milord, item number 33, 3 years conviction, Milord, petitioner behind bar in judicial case.
What do you want?
Milord, Monday, Milord. 3 years conviction, Milord.
Monday, again you at 4:30 you will be.
Then
before-
Tuesday, Milord. Then Tuesday.
Let the registry give this. Mr. Bordul.
Lordship, I have a small submission, Lordship, with regard to item number 61, Lordship. Even the matter is wrongly listed in orders, Lordship, it should be come in motion, Lordship.
Item number 61.
Can it be on tomorrow, Lordship?
Item number
Because
61
NBW has been issued against the petitioner, Lordship.
to be listed in motion column on the date to be fixed by registry.
Monday,
Item number 51.
Other matters,
Regarding item number 31, my lord, as the inquiry, my lord, final report has been submitted. So we'll do it. Okay.